Hello everyone. I hope this message finds you fit and fine. My name is Shashank Tyagi and I welcome you all to StudyIQ. Keeping your prelims in mind and challenges which many students face with Indian polity, we are starting this full-fledged series on Lakshmikant on this YouTube channel. And the title you can see is Kanthasth, based on ancient learning practice, where relationship between master and student was such that purpose was that every component of discussion should be absorbed into the mind of student so that it can be readily used. And this is what you need now. First chapter is historical underpinnings of Indian Constitution, right? Now, if I say that Constitution was made in 2 years, 11 months, 18 days, made, then I would like to differ on this point. Constitution was not made in this time period. It was framed in this time period. Yes, that I can agree upon. That we had this Constituent Assembly, they gathered and they used best of their insights and they framed our Constitution. But when I say made, it means you should also consider the roots of the provisions which are enshrined in our Constitution. They were not made from the scratch. There were many laws which were already there in India, Indian Peninsula, during this British administration. So it becomes important for us to understand how was the history of Indian Constitution, how it was weaved, right? So when it comes to this chapter, this chapter is considered most boring chapter. No matter how many times we read 1773 Regulation Act, Pitt's India Act, Morley Minto Reform, but sometimes, one particular dimension or other point, we often miss, right? Because approach of this chapter, generally student have is to cram these points, right? We're not going to cram. We're going to understand the logic of these provisions, right? How one particular law connects to another particular law. Okay. Now, in modern history, you have this chapter, Advent of Europeans, right? And within that particular chapter, you read about Advent of Britishers into India. A private company, English East India Company, entered into Indian Peninsula to have some trading relationships here. Along with them, they had one paper. That paper was Royal Charter. Charter means a permission which was granted by the Queen of Britain that, oh, you have my permission as well as protection. Now continue trade. And in this particular permission, English East India Company asked for monopoly. It means no other British company will engage in trade in this area. And such monopoly was granted by Crown. Some of you might be thinking, why this monopoly was given to this English East India Company by the Crown rule? And one reason is that shareholders of this English East India Company were for the most influential people of British, at that particular time. Those who were living in Britain, having strong connections in the British administration. Now the point is, it was not one-sided, means it was a quid pro quo relationship. They were paying huge amount to British Crown. If I give you an idea that comparing the currency rates as of now, the amount which used to be paid annually was 46.1 million pound. And it is equivalent to roughly 460 crore rupees. I'm considering the inflation and currency value as at this point of time. So this much amount was given to get this monopoly right. Now English East India Company came as a trader, but extended as a territorial power. Battle of Plassey and later the crucial Battle of Buxar changed the game in favor of English East India Company. As we saw, Treaty of Allahabad Treaty. And after this Allahabad Treaty, this private company this private company got Diwani rights. When I use the word Diwani rights, it means now this company was having power to collect revenues from the subjects in that area. And in which area? Bengal, Orissa, Bihar, big provinces, right? Now, they got this right to revenue collection. But it was projected that now fortunes of English East India Company are going to multiply. But more than English East India Company, the officers got rich. There was massive corruption within this private company, and this alerted British administration. And this British administration now thought, now is the time to regulate the affairs of this private company in India. And from there, this first step means Regulating Act 1773 came into being. At this particular time, there was huge debt on this particular company from the side of Bank of England. British administration was well aware that we have given monopoly rights to this English East India Company, and it is strategically important for us to have a hold in this area. So only way is to make this company run. But now this company won't run on the whims and fancies of the officers. This company will be run by active involvement of British Empire. And within this backdrop, we saw this Regulating Act 1773. There were three prominent, you can say, objectives, three prominent points you can remember. One was to regulate the affairs because a lot of corruption was there, right? Second, recognize the political and administrative rise of the company, because by that time it was quite clear we gave this company charter to engage in trading relationship, but now this company is having political powers, Diwani rights, right? So after this, British Empire accepted. Okay, we are accepting it. Third, foundation of central administration in India. Now, what does this point mean? As I told you, Diwani rights, right? So, by this time, British Empire and this British East India Company got hold in Bombay, Madras and Bengal province. A private company having hold in these three areas became a territorial power. Now, British administration wanted some kind of centralization. Means there should be one point of contact which is having more power than other provinces. Means Bombay and Madras. Now, apart from this, we are going to come to this discussion of centralization, right, through a map. But apart from this, you should also remember certain features, because sometimes questions are asked in match the following or statement wise on these features. First feature you should know is that position of Governor of Bengal was turned into Governor General of Bengal. Please remember the word is Governor General of Bengal, not Governor General of India, right? It means there will be Governor of Madras, there will be Governor of Bombay, but Governor of Bengal is now Governor General of Bengal, right? A step towards centralization of administration. Now, establishment of Supreme Court in Kolkata. And I personally feel that a lot of scope is there to have some trap questions from this particular provision itself. And some provisions are not even mentioned in Lakshmikant. How can question be framed? For example, if I make a statement that as per 1773 Regulation Act, Supreme Court was established in Kolkata, so that statement is correct. When it comes to judges in Supreme Court of Calcutta, which was started after 1773 Regulating Act, these were appointed by Governor General of Bengal. Do you think that statement would be correct? What do you think? I'm saying a Supreme Court was established in Kolkata as per provisions mentioned in 1773 Regulation Act. Actually, that Supreme Court was established in 1774 as per this act, which 1773 Regulation Act. And you should also be clear in mind that this act is being passed where? In British Parliament. Okay. And British Parliament is passing this act to regulate a private company which has gained political power as well as commercial power in this Indian peninsula. Okay. Now, I'm saying judges in this Supreme Court are being appointed by Governor General of Bengal as per 1773 Regulation Act. That statement would be true or false? That statement would be false. Okay. And if I say another statement I'm making, adjudication power of Supreme Court, which was established as per 1773 Regulation Act, was extended to British subjects as well as natives in India. So that statement would be true or false? What do you think? And when I say natives in India, you can also specify natives in British provinces, or you can say natives in, say, Bombay, Madras and Kolkata provinces. I've made the statement, more specific. Now, what do you think? Most of you would say, oh, ये क्या क्वेश्चन हुआ, तो लॉलीपॉप है. क्यों? Because Supreme Court है. Provinces we have just talked about, Bombay, Bengal, Madras. So it's obvious that whether we are talking about British subjects, Britishers in these provinces or natives living here, the power should be, extended to all. But that statement would be false. Because that power was not given in 1773 Regulating Act. So these are reading between the lines. These are the areas where UPSC can lay a trap. That's why sometimes questions are asked from this particular chapter, but statements are like students have read, but they're not able to answer. Right? Now, prohibited the servants to actually take bribes because this was the major cause. Right? Strengthen the control of the British government. It means now court of directors are representatives of English East India Company. These are the key players in the affairs of the company. But they were given direction that you have to report on the revenue, civil and military affairs in India to the British government. Right? So you can easily remember Governor to Governor General of Bengal, Supreme Court case. Then prohibition means corruption. Prohibition on corruption means you cannot purchase, you cannot have gifts from natives, and then strengthen control. Now, we have used the word centralization of power. Just take a look over this map. Bombay, Bengal, Madras. As per 1773 Regulation Act, Governor General of Bengal was also given an executive council of 4 members. When I say executive council of 4 members, it means this council is going to support Governor General of Bengal in taking crucial decisions. But the twist is, earlier Governor of Bengal used to take decisions on its own. But now after 4 members in Executive Council, the decision used to be taken on the basis of majority. So Governor General of Bengal, Mr. Warren Hastings, were not quite happy with that provision. But the point I'm trying to make here is, the name is Executive Council, but it had both executive as well as legislative power. When I say legislative power, it means to make law, executive, to ensure implementation of law through, various offices. So it had both powers, right? Now, similarly, Governor of Bombay also had power, executive as well as legislative, with respect to this province. Madras governor also had powers, executive, legislative, with respect to Madras province. Now, some of you might be thinking, then what is the centralization? So now Governor of Bengal is now Governor General of Bengal. 1G is also added. It means the legislative powers of Bengal governor, legislative powers of Madras governor, some powers are being transferred to Governor General of Bengal. That is why it is said that it is the first step towards centralization of administration in India. right? Please remember this. That's why I've put in bold, because UPSC has asked this question, directly putting it in a statement. Now, in the year 1774, Supreme Court was established, as I told you, right? Now, its jurisdiction was in Bombay, Madras, and Bengal. But there will be a twist here. 1773 Regulation Act was saying its influence or its adjudication will be in all three provinces. But in the next act itself, this particular provision got limited. It means if a question is asked that with respect to adjudication power of Supreme Court established under 1773 Regulation Act extended till, so as per this act, yes, available in all three. But if same thing is asked and the year they are mentioning is say 1781, 1782, then meaning of statement would change, because by then power of this Supreme Court was curtailed. These are some intricacies which sometimes students miss, and UPSC play on this. And we are also going to tell you why this power was curtailed. You need not to just cram. Now, it was court of record. Its power extended to both civil, criminal cases, but just take a look. Only over British subjects, not natives. Trap is here. Only on British subjects in 1773 Regulation Act. Later, this power was expanded, but at that point of time, only on British subjects. What is the meaning of British subject? British subject means British people living in this territory. Apart from this, so British people living in this territory, along with this, employees of English East India Company and their servants. Okay, so all of them were covered. It means if some Indians were actually working in English East India Company, then naturally they will come under the adjudication of this particular Supreme Court, but not natives. Okay, and some of you might be thinking, then why we are saying it as Supreme Court? My friends, this is first step of regulating the affairs of a private company by British Parliament. First step. And they want to regulate this private company because this has created headache to the British Empire. Right? Judges were to come from England. So the question I asked, that who is going to appoint the judges? Crown is going to appoint the judges. Okay, not Governor General of Bengal. The first Chief Justice was Sir Elijah Mfe. Now, what happened after this 1773 Regulation Act? Mr. Warren Hastings were not happy. He filed he sent so many letters to the London. What you have done? I'm a key, you can say, member of this private English East India Company, and my duty is to give profits to the code of directors. And you have actually put so many limitations over me by having this institution of Supreme Court here. This is wrong. Because my friends, this Supreme Court, establishment of Supreme Court after the 1773 Regulation Act was a first institution in India which was independent of private company, that was English East India Company. Because the Supreme Court was not actually going to work under English East India Company. Otherwise, in all three provinces, all the offices were being run under East India Company. So now Warren Hastings thought, this is like you are establishing a parallel powerhouse. I'm not going to agree on this. So he was having many powerful friends in Britain. They also, pushed his agenda to the British administration. Finally, they agreed. They said, okay, finally you are the one who is going to actually control the administration there. You are the one who is going to give the profits, and from this profit, British Empire is having high amount of taxes. Take it. We are agreeing on these grievances, and that's how Amending Act 1781 was made. Now, to rectify the defects of Regulating Act 1773. So what defects we are talking about? See, demarcate relations between Supreme Court and Governor General in Council. So it was like, now Crown is saying, lo, tathastu, krapa barsegi. Now division has happened. It settled the question of jurisdiction of the Supreme Court. Now, this is just a line, but there's a scope of question here. What limitation was imposed? This is not mentioned here. What limitation? Number one. Now, Supreme Court cannot intervene into revenue affairs of English East India Company. When it comes to revenue affairs, Governor General along with her council is going to have the power. Second, the Britishers, the British subjects, means British East India Company's employees, officers, they got exemption from this Supreme Court. Now some of you might be thinking, what is this? Then why you're calling it Supreme Court? But because when you use the word Supreme Court, what comes into your mind? India's Supreme Court, which is like, considering the previous, so many judgments, or you can say, keeping into mind the legal history of India in post-independence period. And whenever you say Supreme Court is like, among the most powerful organizations in India, right? Most powerful political organizations. Political word I'm using because it's judiciary, and judiciary is part of this whole political structure. Now, but this Supreme Court was not that powerful. Whatever power it had, it was curtailed for the benefit of the company. Now, what were the key provisions? First, change in the powers of Supreme Court, as I told you. It means earlier came within the jurisdiction of Supreme Court when it comes to servants of the company, told you. Now exempted. This is what I have just told you, right? Non-interference in revenue matters, I have just told you. Warren Hastings said, koi interference nahi chalega. British Crown said, theek hai, nahi chalega. But our interest should be, should continue in India. Shift appellate jurisdiction court to Governor Council. What does it mean? It means that appellate jurisdiction means if lower court has pronounced a judgment that you are given this much punishment, then you, by using appellate jurisdiction, you can appeal in higher court, right? Now, since Supreme Court was established after 1773 Regulation Act, appellate jurisdiction came under Supreme Court. From all three provinces, appeals were coming to Supreme Court. And Governor General was saying कि हम ऐसे ही बैठे हैं यहाँ पे. We have worked so hard. So now the appeals went from provincial courts to Governor General in Council. Right? खुश कर दिया Warren Hastings को. Now, assertion on the application of personal laws. Because after 1773 Regulation Act, I have just told you, British subject, not natives. But at this point, this need arises that, we have to take into consideration the natives also. But natives can be, the judgments related to natives should consider their personal laws. It means laws, legal systems related to their respective religions. Only British courts won't suffice when it comes to handling their cases, right? Because if they're not going to agree on the judgments, then what is the use of that judicial system, right? So bring inclusiveness was the objective. Bringing inclusiveness was the objective of this point, and inclusiveness for the benefit of Britishers, right? So Hindu law, for example, Mohammedan law need to be incorporated. Now, after this act, there were still various defects in the system which was running in India. Corruption was still going on. Company was minting money, but British administration was feeling like we are being sidelined. So keeping into this, tackling this maladministration, Pitt's India Act 1784 was made. The most famous, you can say, provision of Pitt's India Act is dividing the working of company into political and commercial affairs, recognizing both affairs separately and having two separate bodies to report on these aspects. So distinguished between commercial and political functions, and their word was used double government or dual government. Why? Because court of directors now was responsible for commercial functions. How much revenue, how much profit you are generating. And board of control, this was a new body which was made, responsible for political affairs. And it was board of control which is representative of British government, and court of director are representative of company. How you can easily remember? Companies में directors होते हैं, right? Directors are the key partners of a company. So you can easily remember, oh, court of director means commercial functions. इनका मतलब profit. What their objective is? To earn profit, to report profit. And board of control, government is the one who is having major power to control. So that is why this was British government, right? Representative of British government, right? So they were appointed by British, right? Now, I also find a beautiful scope there, beautiful scope of question. Now, scope is, if I say that board of control was headed by secretaries of state. So there's a statement that which of the following statements are true as per Pitt's India Act 1784. Okay. So this is the key statement, and within which you can have 1, 2, 3. So first statement is that board of control was headed by secretary of state, full stop. Now tell me that statement would be true or false. If you have gone through this chapter, so you must have read about Government of India Act 1858, from where we see crown rule in India. And there you read about Secretary of State for India. A new office is being created. This office will be in Britain and will be responsible for the affairs in India. We are going to talk about it. But the point I want to make is that when you open your Lakshmikant, Secretary of State for India is more focused when you read about 1858, Government of India Act 1858. So many students would think, oh, it may be possible that this examiner is trying to have playing a trick here. कुछ लग रहा है कि examiner फिर की ले रहा है. Secretary of State तो अभी नहीं हो सकता. Secretary of State was created in Government of India Act 1858, है ना? ऐसा ही सोचोगे? एक तो होता है गलत, एक होता है सरासर. वो सरासर गलत हो जाएगा अगर ऐसा सोच रहे हो. Why? Because Board of Control was presided by Secretary of State. And I have not said Secretary of State for India. I've just used Secretary of State. So in Government of India Act 1858, this office which was created was Secretary of State for India. And this is just Secretary of State. And in UPSC polity questions, UPSC play on these small words. Now, what were other provisions of Pitt's India Act? As Governor General of Bengal was not happy with this fact that you have made these 4 members here, and all of them are you actually actively engaging into decision making based on consensus. I'm Governor General of Bengal, at least give me some more power. British Parliament said tathastu, जाओ कृपा बरसेगी, मान लिया तुम्हारा. Reduce the strength of Governor General Council to 3 members, and Governor General was given right to veto. It means even if majority of these members are saying that we are in favor of this law. So earlier consensus was ruling, but now Governor General would say, oh, have you read the new act, Pitt's India Act? Now I have veto power. हमारी मर्जी नहीं है. I'm not agreeing on this. If I'm not agreeing on this, you cannot allow. Right? Place the Indian affairs under the direct control of British government through Board of Control, as the word is control. Companies' territories in India were called British possessions in India. This happened for the first time, right? This statement, a question was asked on this statement specifically earlier. Governors' Council were established in Madras and Bombay. My friends, I hope you remember. 1773 Regulation Act. Through this, Executive Council, 4 members, created where? Governor General of Bengal. Governor of Bengal, given status Governor General of Bengal, and 4 people were given. But these fellow were not given any supportive system. Now, कृपा इन पर भी बरसी और इनको भी हमने council दे दी. Now, the Board of Control took care of civil military affairs, as I told you, political affairs. So, the civil and military affairs come under political affairs. So, that's why this is being taken care of by Board of Control, right? And commercial affairs are being taken care of by Court of Directors. Now, you can see it. So, I asked this question from here. So, Board of Control is having 6 members, right? 6 members. Please remember, these kind of facts are also asked. Headed by Secretary of State, Board President, then Chancellor of Exchequer, taking care of this particular position is going to take care of revenue. Now, 4 Privy Councillors. These were other members of this Board of Control which were appointed by British administration. Now, in this dual system because Board of Control, Court of Director, the company was represented by, told you, Court of Director, and British government by Board of Control. Now, this act mandated all civil officers disclose the property. Yeah, this was another important, that if you got appointed as officer in English East India Company, you have to report about your property within 2 months. Now, since you are aspiring to be part of Indian administration, there is a similar clause in India's case as well. When you are going to join LAPSNA, so you are going to sign various forms in the orientation program, you will be intimated that within this time you have to give all the details of movable, immovable properties you have, so that a track can be, put over you, how much wealth you have created within 2-3 years, right? Hope you can understand the objective. Now, as I told you, there's a difference between Secretary of State and Secretary of State for India. So this is Secretary of State for India. This position was created in Government of India Act 1858, right? But we are still in 1784. There's a difference. Other provisions. Governor General's Council strength was reduced to 3 members, already told you, and one member is going to be Commander-in-Chief of British Crown's Army, right? It means if we are giving some relaxations to Governor General of Bengal, we are also keeping a tab, right? Keeping accountability. Governor General was given right to vote, already told you. Members reduced from 4 to 3, but right to veto was given. If Governor General of Bengal is not agreeing, then that decision cannot pass. Simple. The presidencies of Madras and Bombay became subordinate to the Bengal. It means more legislative power transferred towards this Governor General of Bengal. In effect, Calcutta became the capital and the British possessions in India. Remember, British possessions in India, this particular phrase was used for the first time in 1784 Pitt's India Act. Now, what were the drawbacks? First of all, not much clarity was there between the functions of Board of Control and Court of Directors. And that's why now Governor General of Bengal made good use of this opportunity. So, there was no clarity on the boundaries, and Governor General had to serve the 2 masters. That we have to serve the Court of Directors as well, because Governor General of Bengal is ultimately serving a private company. So the key investors are there sitting in Britain. So that particular person, this office has to report to them how much profit you have generated, what are your strategies in future. And there's another second master, which is British government. There were no clear boundaries between responsibilities. As I told you, Governor General had to take spot decision exercising discretion. So whenever there's no clarity between these 2 power centers, so who used the power? Governor General of Bengal used the power, obviously, right? Because in India, we are moving towards centralization. And who is the key power here? Governor General of Bengal. Now take a look over these questions. Quite direct question. Under which territory of the company was first named British property? I've told you, Pitt's India Act 1784, right? Now second question is for you. Just read the question and attempt. Coming to Charter Act 1813. Look, company's monopoly over Indian trade was terminated. That's a fact under Charter Act 1813. But there's an interesting insight here. Those who are also interested in world history, I would like to ask you, what was happening in Europe at this point of time? I hope you must have heard about or read about continental system which was laid by Napoleon. It was a blockade by Napoleon, which was planned by Napoleon to actually, you can say, restrict the trade interests of Britain with other European nations, right? So it means the other companies of working under the British Empire, they were like, we are also private company, like English East India Company. And it was your political matter with Napoleon. And why we have to suffer? And if we are going to suffer, then how we are going to pay you the taxes? Then British government was like, so what should be done? So they said, why not give us access to Indian Peninsula? Why only English East India Company is given access to Indian Peninsula? We should be allowed to have trade there. So then British government was like, yeah, for its own betterment, it is better to allow other companies also to trade there. So when this English East India Company came there, that we want permission to trade again because we also need protection. So they said, now your trade monopoly is terminated. But monopoly in two aspects were there. It means tea trade. In tea trade, only English East India Company, this private company, will continue in Indian Peninsula. And with China also EIC will continue. Otherwise, now other private companies of working under British Empire started coming in India for their fulfilling their trade interest, because they were suffering huge losses due to continental policy of Napoleon, right? Another important thing of Charter Act 1813 is education. Because it was under this act that British government earmarked 1 lakh rupees annually for modernized education in India. So the purpose was that we need people to run the administration. We need to give them specific skills so that they can be of use to us. And when you read same period in modern history, you also read about the debate between vernacular and Anglicist medium of education. What should be the way? But that is in history part. But you should connect things, right? That's how you consolidate your knowledge easily and reproduce in exam easily, right? Now, apart from this, Britishers also gave this logic that there's a you can say abundance of literature in India, and we want this literature to be interpreted in English and other languages, and to be it should be exposed to the world. And for that we need people, Indian people, to cooperate with us so that they are also able to transfer their knowings about their scriptures to other languages. So this was another logic which was given. But you should remember, okay, the monopoly was abolished, exception, and education. So these are the three key part. Now comes Charter Act 1833. You can say, you should remember certain phrases with it. For example, final step of centralization. Why? The reason is, you can see William Bentinck, because now Governor General of Bengal was given the status of Governor General of India. My friends, Britishers till the last point, means when they gave us independence, they were saying India is not a nation. They said India is just a geographical unit which got united administratively because of our laws. So which law they are referring to? They were referring to Charter Act 1833 as a start. Because now the seat in Bengal is going to be representative of British interest across Indian Peninsula. That is why centralization word was used, right? Now, Governor General of India, I told you, all the regulations will be now acts, and now English East India Company will solely be administrative unit. It means earlier you were having a lot of commercial interest, but now British Empire was like, British government was saying that, okay, now your commercial interests are actually impacting the administrative proneness. And that is why now English East India Company should absolve, remove commercial aspects and just focus on administrative aspects. Now, the investors of English East India Company who were sitting in Britain, they were like, now what is going to happen with our profits? Then British government was that since this administrative unit is responsible for collecting revenues, ensuring policies so that your revenue stream are streamlined, then definitely there will be nothing, your profits will be secure to the point. But now the mode of profit will be this. Now, along with this, English East India Company, who was representing commercial interest, Court of Directors, they were saying that no open exam for covenanted civil services. My friends, it was Charter Act 1833 in which for the first time this idea was floated that there can be an open exam for covenanted civil services, means higher post in administration. But English East India Company and Court of Directors, they were opposed to this idea. Now, why they were opposed to such idea? So that they can have their grip on the administration in India. Because if it is happening through open exam, then these bureaucrats, they won't listen to this private company, although they are part of administration, which this administration is being run by a private company. Surprising fact is that administration in India being run by a private company allowed by British government, and these private investor did not wanted these officers should be working independently. So that is why there was a Halsbury College in London where you have to take admission so that you can be part of this covenant civil service, and you could not take admission there without sponsoring letter of COD. So in that way, they were maintaining control on who is going to be there working as a bureaucrat, right? So they did not wanted to lose their control on administration in India through English East India Company. Although opposition started, you can say boiling, from 1833. Now there was an attempt, that's why the word attempt is used. It was not introduced. It was introduced later. Charter Act 1853. You should remember these differences because UPSC play on these words. Okay, these small words make a lot of difference, right? I told you why they opposed, right? Now Charter Act 1853. So you can say that this was that period when rule of English East India Company was on decline. Now Crown was all set to take the power. The legislative and executive functions of the Governor General Councils were separated. Till now, what was happening? Governor General's Council, now who was Governor General of India's Council, was taking decision with respect to making laws as well as executing laws. But now after 1853 Charter Act was said, no, there should be separation. There should be a separate legislative body. Law making should be separate and execution should be different. 6 members in the Central Legislative Council. 4 out of 6 members were appointed by provisional governments of Madras, Bombay, Bengal, Agra. It means Britishers having their provisional. It means government at the level of state. You can say province, right? So they have their government there. So each government will have power to send 1 member to the Legislative Council at the Governor General's level, so that when laws are made at the level of Governor General of India, the interest of these provinces can be taken into consideration, right? Now, it introduced a system of open competition. As I told you, attempt was made in Charter Act 1833, but it was not introduced because COD, means Court of Directors, was opposing this move. But now it was introduced, right? It was introduced as the basis of recruitment for civil servants. So those who are preparing for civil services, you should be thankful for Charter Act 1853, or you should remember at least, because it was this act which actually started this exam for which you are preparing, right? So this was last Charter Act. Why? Because after 1853, now tell me what happened in 1857. So in 1857, we had first struggle for India's independence. They call it mutiny. So at that point of time, now British government got alerted that now having sound administration in India is not in the hands of English East India Company. And this revolt of 1857, there were several reasons like annexation, exploitation. You read about them in modern history. Doctrine of lapse, conversion policies, westernization, introduction of new Enfield rifle. You know all about this, right? In modern history, what were the reasons of 1857 revolt? Our purpose is to look into the legal aspects, how our law was evolving. The background of constitution was getting shaped due to these events. Now after this, now Queen Proclamation was done. It means now British Empire said company rule is over. Now there's a start of crown rule in India. So Government of India Act 1858 started. Okay. So now what difference does it make? So Queen said my law, means Government of India Act 1858, would be different from EIC's rule, English East India Company's rule, because now I'm going to ensure a responsible government there. I'm going to ensure good government there, right? And the concerns of Indians, many princely states were fearful that they may be acquired. Now Queen said, wherever are the territories of Britishers in India, they cease to be there. It means no further expansion will happen. So act of good government in India, answerable and responsive government. Now my friends, answerable and responsive government, don't misconstrue it by thinking, oh, Queen was thinking about us. She was saying now this good government in India will be answerable and responsive to the people of India. ऐसा नहीं था. Reality was these two words, answerable and responsive, to British government, to British Parliament, हमें नहीं. Okay? वो change अभी आएगा. That change is going to happen soon when I'm going to talk about Councils Act. लेकिन अभी तो Government of India Act 1858 की बात चल रही है. We are still talking about this. So Queen's Proclamation of 1858 started. Now, earlier you know there's this position that Governor General of India. Since now there's a start of crown rule from 1858, now there was another word which was adopted, that is Viceroy. Viceroy, it means representative of crown. Okay, so apart from this, a new position was created, Secretary of State for India. Secretary of State for India. This office was supported with 15 members in its council, and this office was maintained in London. But when it comes to expenditure incurred in this office, it was going from India, right? So that was one concern among many revolutionaries or nationalists. Now, the Indian administration was under the authority of Viceroy, because Viceroy was representative of Crown. So now, Governor General was given this title of Viceroy. As I told you, now company's rule is done. So that is why Court of Director and Board of Control, both segments were abolished. Okay. So if I ask you this simple statement, means I'm making a statement and you have to tell me the statement is true or false. Okay? This is just a test to actually ensure that everything is getting concussed or not. So statement is, it was through Pitt's India Act that office of the it was through Pitt's India Act that Board of Control and Court of Directors were created, comma, but after Government of India Act 1858, both were abolished. Now tell me, the statement is true or false? I'm repeating my statement. I'm saying Board of Control and Court of Director, these two segments of administration of English East India Company in India were created through Pitt's India Act 1784, comma, but abolished after Government of India Act 1858. Tell me, what is going to be the answer? आपके मन में जो आता है आप बताइए. Because the rule of psychology, if you make mistake, and I'm going to pinpoint this is the mistake, and now you are going to be safe. Now you are not going to be trapped by UPSC. Those who are saying yes, हाँ ये तो पढ़ा हुआ है, पिट्स इंडिया बताया था सर ने, बोर्ड ऑफ कंट्रोल कोड ऑफ डायरेक्टर, हाँ हाँ हाँ, क्लास ही इससे स्टार्ट की थी, अच्छा. But please give attention to each word I say. In the previous class, I also focused on this part, that court of director was existing already. This court of director, who was representing the interest of this private company, was existing already. Board of Control was created as a new entity through Pitt's India Act 1784. Yes, you can say the division of power, this commercial functions and political functions, this was done in Pitt's India Act. But my statement is saying Court of Director and Board of Control were created from Pitt's India Act 1784. So those who are saying this is yes, मैं आपको बताना चाहूंगा, एक तो होता है गलत, एक होता है सरासर. ये सरासर गलत है. बात पकड़ में आ रही है आपको? तो these are some, kind of some words here and there, and that's how UPSC lay the trap. Okay, please remember, categorization of function in Pitt's India Act happened, yes, but creation नहीं था दोनों का. Creation इसका तो पहले ही था, पहले दोनों काम देख रहा था, इससे कहा कि नहीं तुम एक काम इसको दो. ये हुआ था Pitt's India Act में. Okay, so this was done in Pitt's India Act. Now, Lord Canning, who was the viceroy at that point of time, so he took a decision. Means after this Government of India Act 1858 was enacted, now Lord Canning, he thought we need to change some aspects in administration of crown in India, because now there is crown rule. So he said we have to involve more Indians, otherwise there will be several grievances, and these grievances will lead to rupture of certain revolts. So it is better to involve more Indians and develop and evolve legislative councils. Councils means there will be several members, and these members will participate in law making process, so that now Indians will not say that, oh, we are not going to follow this law because this law was made by Britishers. Since many Indians are going to be incorporated in this legislative council, now it can be said as a reply that, oh, we have Indians also in legislative council, right? Your own brothers and sisters are making law now. It's not just Britishers are enforcing. So by this logic, it was a first step, right, to actually involve more Indians. Now, there are three councils act, Indian Council Act 1861, 1891, and 1892 and 1909, right? Now, first step, Indian Council Act 1861, to ensure that we need to give representation to Indians, three Indians were actually appointed here. Who were they? Raja of Banaras, Maharaja of Patiala, and Sir Dinkar Rao, right? Now the point is, who was appointing them? They were non-official members, and they were getting appointed by Viceroy. Okay? Apart from this, portfolio system was introduced. Portfolio system, what does it mean? एक तो होता portfolio, photo वाला portfolio, that you are entering into some modeling or something and then you are having portfolio album. That's not the portfolio we're talking about. My friends, we have to connect. Okay, this particular terminology in our administration was introduced through this law, and we still have this particular mechanism in India. Means this mechanism was there in Indian Constitution also. So this is how we need to connect our understanding. Portfolio system you can equate with system of Council of Minister. It means, now in Executive Council, it is not that collectively this Executive Council is responsible for every executive work, every department work. Now, let's segregate the department work. Now, if Viceroy has to take answer from any Executive Council member, so there is a separate, departments allocated to this. So now it means Mr. Robert may be asked, Mr. Robert, give me the status report on agriculture. Give me the status report on finance. Mr. Jackson may be asked, Mr. Jackson, since you are given the portfolio of road and railways, I want report on road and railways. We made a policy on road and railways. What happened in past 6 months? Give me the report. So now individual responsibility within this Executive Council was termed as portfolio system. Later, we know it in the form of Council of Ministers system, where portfolios are allocated to different ministers, and Prime Minister directly asked that concerned minister, okay, give me the report what your ministry has done, right? So there is portfolio system, and it was introduced in 1861. Decentralization initiated in the presidencies of Madras and Bombay. My friends, from 1773 to 1858, we have seen a trend of centralization of power. It means earlier there were governor of Bengal, Madras and Bombay. Then governor of Bengal was given the title of Governor General of Bengal. Then that particular position was given to the title of Governor General of India. So it means this is how power was actually being centralized there, right? So now this centralization trend got into reverse now. So how it get into decentralized. Okay, so now decentralized का मतलब क्या होता है? Now power is being devolved at the provincial level also. Okay, and we have seen that this decentralization which started from Council of India Act, Indian Council Act 1861. So now it went till Government of India Act 1935. Government of India 1935, which is like lot of provisions of Government of India Act 1935 are taken into Indian Constitution, and among them the important one is federal system, division of power between states and union. So this is an example of decentralization, which we are going to talk about it in Government of India Act 1935, but you should also remember from where it started, because UPSC can make these kind of statements too. Okay. Now, just attempt this question. Indian Council Act 1861 provided for decentralization tendency. Legislative Council for Punjab rejected the portfolio system, started associating Indians with law-making process, and these are the options. You have to attempt this question and then answer in comments. In some acts, what I have done, we are discussing all important provisions. Along with this, we know that UPSC is not going to ask directly from the statement. They may infer, they may check what you infer from the statement which you have read in Lakshmikant, right? So in that case, I would advise you to open this particular act, read it, and then attempt. Answers are going to be shared in the Telegram group as well, right? And the method which you should use is elimination here. Okay, because for example, you have gained the understanding that portfolio system was introduced. So how can this be true? Reject it. So it means this is no, right? Decentralization tendency, we already know. What you don't know is that Legislative Council of Punjab, whether this was introduced or not. right? And started asserting with Indians lawmaking process. This is also correct. I've already told you this was the whole purpose of Lord Canning. So it means 4 means 1 and 4 and 1 to 4. These two are mentioned, right? And Legislative Council for Punjab. The purpose of Indian Councils Act was not just to take into consideration the councils at the level of center. We were talking about the councils at the level of provinces also, right? Answer is 1, 2 and 4. Okay. Now, Indian Councils Act 1892. So it increased the number of additional. Purpose was to expand the involvement of Indians, non-official members in central and provincial legislative councils. Now, important is not means it. You need to identify the trick part, but maintain the official majority in them. The trick will be played here in the bold part. What does it mean? It means non-official members are being involved. It means they are not part of British, you can say British administration. They are representative of people. Okay, means they may be you can say expert in certain areas, that's why they are being involved, but they are not officials. And when it comes to decision whether this law is going to be passed, how that decision is taken in Legislative Council, this is taken on the basis of majority. My friends, if non-official members are not in majority, do you expect that they can propose some law for the betterment of Indians and they can actually ensure that this law can be passed without support of officials? No, this can't happen. So it means although a step was taken for having more involvement of Indians, but means Britishers were not having genuine interest to give us the power that we can actually propose the law and we have the majority, we can pass the law, and then Britishers will be there, oh, since you have passed the law, we are going to implement it. No, this was not the case there. So please remember, Indian Council Act 1892, but maintain the official majority in them, both central and provincial, right? One tricky question can also be made where UPSC can say official majority was maintained at provincial level but not at central level. Okay, these kind of you can say traps are laid. Now legislative councils were expanded, gave them functions, legislative councils such as budget and questioning the executive. Now this is important and this is good aspect, you should say, because now at least you can ask question from the executive. And don't you think in our parliament, our legislature, questioning is the essence of democracy, right? All the members have this right. If they want to ask question from any minister, they can ask that question. They have to send the question in Lok Sabha to the speaker, and then speaker will select, categorize this question and send these question to the concerned minister, right? So questioning, power of questioning in our legislature entered through Indian Councils Act 1892. Now, Indian Councils Act 1909, famously known as Morley-Minto reforms. I would say infamous. This particular act was infamous also. Infamous, why? Due to communal electorate, right? Now, direct elections to the Legislative Council, first time, the number of members of the Legislative Council was increased from 16 to 60. So when I'm saying direct election, don't consider that all the people, universal adult franchise got into it. No, aisa nahi tha. Limited franchise was there. Only few people were given right to vote, right? And they were the one who are participating in elections. This particular reform is famous for the separation of communal electorate. What does it mean? When you use the word electorate, what does it mean? And when I'm saying separate communal electorate, word communal means based on community. You have separate electoral features. What does it mean? For example, Morley-Minto reform saying Muslims are going to be given separate electorate. In a particular area where a seat is allocated as a Muslim seat, there only Muslims are going to vote and Muslim is going to fight the, you can say, election. So this idea, although was supported by many Western, you can say, political thinkers of that time, they were saying in a society where there are minorities, and to ensure that minorities have their say in administration so that they are not suppressed, we should introduce separate electorate. But my friends, there is a huge demerit also. For example, in an area, it was not like that in our society people were living that in a particular constituency only Muslims are going to live and other constituency Hindus are going to live. We were a diverse society interweaving with each other, right? So at that point of time, in a particular neighborhood, if Muslims are the one who are allowed to vote and Hindus can't vote, other religions can't vote, now don't you think this particular process of electorate will actually have huge negative implications? Number one, division of the people, right? People would say ki we don't have voting power. And second is that representative will only come at the door of people who are going to vote, who are going to ensure his success, his candidature to actually get get appointed after election. So the point is that this will actually be a negative connotation, राइट वो पूछेगा ही क्यों दूसरे को, वो केवल उसको पूछेगा जो उसको वोट दे सकता है, उसी के डोर पे वो जाएगा कि बस आपका ही वोट है, इनको तो छोड़ो. Those people, if they will come that we have these local issues, then that person would say ठीक है आप बाद में आना. But those who are the actual voters, that person will give premise to them, right? So this is the fault of the system, right? It is said that Britishers introduced this to divide Indian society on communal lines. For the first time, Indian was made as the member of Executive Council of Viceroy, and the name was Satyendra Prasad Sinha as law member. Now, just check out this question. Consider the following statements. Morley-Minto reforms. Provincial Legislative Councils came to have non-official majority. The discussion on budget, including supplementary question, was introduced. For the first time, Muslims were given separate electorate. Morley-Minto reforms. So you have to attempt that question. Okay. Now, Government of India Act 1919. Montagu-Chelmsford reform. Okay. And when I'm saying Morley-Minto or Montagu-Chelmsford, it means Minto is Viceroy and Morley is Secretary of State. Okay. Chelmsford is Viceroy and Montagu is Secretary of State for India. Now, 1919, important law, can easily remembered on the basis of division of power and how power was divided. Take a look. Legislature list got divided into two parts, central subject and provincial subject. It means earlier this council of this Governor General's Council, after that we had this Central Legislative Council, it was having power to make law on every subject, and on some subject there was huge overlap with provincial Legislative Council. So their need arose that why not we divide our spheres. It means if certain laws can be made by provincial legislature because they have better know-how of the ground situation, then these powers should be given to provincial legislature. If certain laws need uniformity across different provinces, then these subjects, to make law on these subjects, this power should be given to central legislature, right? So that's how this categorization was done, central subject and provincial subject. Okay. And you also know that in our Indian Constitution, Schedule 7, we have union list, state list, and we have also concurrent list. So union list simply means the matters on which only union legislature can make law, parliament can make law. State list, matter on which state legislature is going to make law, right? So this idea of categorization of subjects between union and state, it emerged where? 1919. You can use your pictographic memory. It means understanding one thing is, one way, right? And another is associate with some picture. Okay, 1919. Oh, there was division happening, right? So in this way, you can actually remember this. Apart from this, when it comes to provincial subjects, they were further divided into two. One was reserves list and other was transferred list. Reserve list means now only Governor General of that province, along with the concerned members of council, they are going to take this decision. For this taking decision on these reserve list subject, they are not bound, answerable to the council. But when it comes to transferred list, with regard to these topics, which are these subjects which are mentioned in this transferred list, they have to take into consideration the process of council. It means important subjects were taken in reserve list, so that the members, the Indian community members in this provincial legislative council, so that they cannot question this because they don't have any say over this. But when it comes to some, you can say, some too simple kind of subjects, right? Basic things, they were given into transferred. Okay, on these things you can debate, you can bring law, you can bring bill, and then we are going to discuss, and then we are going to make law, right? So important things were kept in reserved list. So this division of subjects is called as diarchy. Dy means, Di means say two, archy means rule. Diarchy means rule in two ways. Two ways, why? Because legal subjects, the subjects on which law can be made, is divided into two parts. Okay, please remember, diarchy means the subjects on which laws are going to be made. These are divided into two parts. One, reserved means Britishers, their governor at the level of province, along with the council members, they are not accountable to this legislative council, reserved, and here they are, right? So this division is known as diarchy. Although there was a lot of, you can say, opposition to this very idea, right? Because you have given, certain subjects and transferred, but even if we want to raise some points, we want to contribute in law making process on the subjects which are more important, and you have put in reserve list, then this is like a mockery, right? Apart from this, Government of India Act 1919 also introduced bicameral legislature. Bicameral means, now please remember, यहाँ पर अभी तक हम जो बात कर रहे थे वो डिवीजन की बात कर रहे थे. We were talking about division, but we were talking about division of subjects, means areas on which laws are made. अभी केवल उसके डिवीजन की बात की. We were just talking about those divisions, right? Now we are talking about house, like we have Lok Sabha and Raj Sabha, two separate houses. So bicameral legislature, legislative council and legislative assembly word were used at that point of time. In current scenario, you can equate with Lok Sabha and Rajya Sabha. Okay. So majority directly elected, majority in both. Now establishment of Central Public Service Commission. This is important for you, right? It was this 1919 Act through which Central Public Service Commission was established. Now you have UPSC, Union Public Service Commission, right? Limited franchise was there. It means everyone was not having right to vote. Voting rights were given on the basis of property, tax and education. The tax you pay, the property you have, the education you have. Only around 10% Indians were having this right to vote at that point of time. Okay. Another important part, Viceroy's Executive Council. There were 6 members here. Out of these 6 members, 3 members, apart from Commander-in-Chief, need to be Indians. So this was an important development here. Means 6 members in Viceroy's Council, right? Viceroy's Executive Council. Out of these 6, Viceroy's Executive Council ही बोलेंगे हम. Because Legislative Council is separated already, ना? We already have Central Legislative Council, Provincial Legislative Council. Legislature वाला part तो दे दिया उनको, अलग है, वो तो body है. जैसे हमने यहाँ पर Legislature की बात करें. अब Viceroy, Governor General of India, Viceroy, he is already having Executive Council. 6 members, 3 members need to be Indians, right? Now a Simon Commission was made to review the implementation of this 1919 Act. Now, huge, you can say, opposition was done against the Simon Commission because many Indian leaders were having, serious reservations with 1919 Act, saying this is a mockery. You already have made reserve subject. Important subjects are with you. Diarchy you have introduced, right? And true representation, true involvement of Indian has not been realized until now. It was a promise given way back, right? Lord Canning idea, then Council, 3 Councils Act. So now Simon Commission was made to review this. Now the point of contention was no Indian was part of the Simon Commission. In modern history, you must have read about Simon Commission and Simon Go Back, right? Lala Lajpat Rai lost his life, right? Now, 7-member commission, no Indians were there. Objective to inquire about the working of 1919 Act. This objective need to be, you should remember, a statement kind of question has been asked already by UPSC, I think 2015. Now, recommendations. What were the recommendations of Simon Commission? 1. Abolition of diarchy. I've already told you, serious reservations were against this concept of diarchy. क्या मजाक चल रहा है, रिजर्व सब्जेक्ट, ट्रांसफर सब्जेक्ट. तो साइमन कमीशन ने कहा हटा दो इसको, डायरकी को, right? Otherwise, problems will continue. Extension of responsible government in provinces. Continuation of communal representation. Communal representation continue करो, separate electorate. Establishment of Federation of British India and Princely States. Federation of British India and Princely State. Princely State will be member of this federation. So now Indians objected to this Simon Commission, right? And there was, Simon Go Back was going on, though these recommendations were incorporated in Government of India Act 1935. They were incorporated. This is also important. Okay, many people miss on this particular statement, and this particular statement is used. Please remember it. Now, after this, 3 roundtable conferences happened in London, where Britishers invited important leaders from all sections of Indian society so that they can listen to them, their grievances, their suggestions, and check out the future plan of administering British India. So, Gandhiji went only in 2nd conference, and Sarojini Naidu and Dr. B.R. Ambedkar went into all 3 conferences. Representative of British government, representative of India, and representative of Princely State, all 3 segments were present there. As an outcome, McDonnell Award, Ramsay MacDonald, the British Prime Minister at that point of time, was declared. Ramsay MacDonald Award. It means now separate electorate, which were earlier there for Muslims, but now Ramsay MacDonald was saying on the ideas of Dr. B. Ambedkar that separate electorate need to be introduced for depressed sections also. And after this, that many Indian leaders, primarily Mahatma Gandhiji, considered it as an attempt to divide Indian society further by Britishers, and specifically Hindu society, so that they can weaken the, our national movement. So, on 26 January 1930, we had this demand of Purna Swaraj, and then at that 1932 we had this Ramsay MacDonald Award, जिसके बारे में भी आपको बताया, extending separate electorate scheduled classes. Now, what Mahatma Gandhi did? Mahatma Gandhi sat on fast unto death in Yerwada jail, right? Yerwada jail, Pune. And then there was huge pressure on Dr. B.R. Ambedkar that you have to save life of Mahatma Gandhiji, because condition of Mahatma Gandhiji was that this demand of separate electorate for depressed section should be removed. So, under the public pressure, Dr. B.R. Ambedkar went to Yerwada jail. They had a discussion with Mahatma Gandhi, and finally, they both arrived at a conclusion that we are going to find a middle way, and middle way is going to be reservation for depressed classes in subsequent provincial legislative elections, provincial legislative council elections. So this was signed, and separate, reservation is, different from separate electorate, because in separate electorate, it means if a particular seat, constituency is declared as depressed section, for depressed section, now only those categorized as depressed section can vote, and only candidate can be from depressed section. But when you say reservation, it means this particular seat is reserved for depressed section. It means candidate can be from depressed section, but when it comes to voters will be all eligible voters who are residing in that particular territory. Okay, so this was considered as a better way. At that point of time in 1934, M.N. Roy, demand for Constitution in India by Indians, this was raised. Please remember M.N. Roy. Now, there's a question for you. Simon Commission, which was appointed in 1927, submitted. So just take a look over this question, okay, and post your answer in comments. This PDF will be available in the Telegram group. I'm going to show the Telegram address in the last, okay, so no need to worry. Now, Government of India Act 1935. This particular act has a lot of provisions. We have a lot of provisions from this act in our constitution, because why we have it incorporated? Because already administrative structure was developed. So our constitution framers thought, why we should actually dismantle a structure which has already been made? Why should we do a trial and error if we can improvise on a structure which has already been made by Britishers? So All India Federation was proposed, which would consist of British India, princely states, and categorized through subjects, central, provincial, as well as concurrent. And this is exactly the three lists. These are exactly the three lists which we have in our Constitution 7th schedule, right? So center subject means federal list, means on federal list means as of now we use union list, center can make law. Provincial list, it means state list, only state can make law. And when I say concurrent list, concurrent means both can make law. But when it comes to if those two laws which are made on a matter in concurrent list come into conflict, then whose law will prevail? Center's law will prevail. This is a common you can say idea. But my friends, in previous judgments, Supreme Court has arrived on a doctrine where harmonization is done whenever a central and state law came into conflict, some provisions came into conflict. Then there's interpretation of that law so that harmonization can be done, right? Harmonized reconstruction. Okay. Today we are talking about historical background in Indian Constitution. We are going to focus exactly on that, okay? Now, diarchy was abolished at provincial level and introduced at the level of center. Now, if a UPSC is making a statement, as per Government of India Act 1935, diarchy was abolished at provincial level and it got enacted in Indian administration. It got enacted in British administration at the level of center. Do you think that statement would be true? What do you think? True or false? True or false? Come on. Some of you might say, sir, इतना बुद्धू समझा है क्या? लिखा तो है introduced. आपने enacted बोल दिया, एक ही तो बात है. My friends, answer is false. Because it was introduced in the law. It was introduced in the law, means in the law. Government of India Act 1935 has this provision कि हाँ, there should be a diarchy at the level of center. But it never got enacted due to a lot of repulsion against the idea of diarchy at provincial level also in the past. Okay, so these are some intricacies on which UPSC lay the trap. Now, more autonomy was accorded to the provinces. 6 out of 11 provinces bicameral legislature was introduced. So, if I ask, bicameral legislature as a concept was introduced by which law? Come on, हमने अभी बात की है 1919, right? Now, here we are extending it to provinces, right? Different provinces. A federal court was established. Indian Council was established, abolished. Extension of communal representation to SCs, women and laborers. Yes, we are talking about 1935. Pune Pact has already been done, but Britishers were not got deterred from Pune Pact. उन्होंने कहा ठीक है, गांधी जी एंड अंबेडकर ने आपस में पैक्ट किया जिससे कि नाउ अंबेडकर वुड बी सेटिस्फाइड एट द लेवल फॉर रिजर्वेशन. बट ब्रिटिशर्स ने फिर भी गवर्नमेंट ऑफ इंडिया 1935 में सेपरेट कम्युनल रिप्रेजेंटेशन की बात की, राइट? नाउ एक्ट प्रोवाइडेड फॉर एस्टेब्लिशमेंट ऑफ RBI. It was this act through which RBI got established, right? Reserve Bank of India. There was a separate law for Reserve Bank of India also, right? RBI Act 1934. And so RBI Act 1934 came earlier, and how RBI is going to position or interlinked with the administration, these provisions were mentioned in Government of India Act 1935, right? And RBI got established in 1935. This act continued with its placed in new Indian Constitution, as I told you, and at that point of time, around 10% people were having power to vote. Now, this is an MCQ for you on this. Take a screenshot and attempt. Now came the August offer. Now Britishers were in trouble. In 1935, World War II got started. Hitler was in position to attack Britain. And at that point of time, Britishers wanted support of Indians, right? So now Britishers were saying that again, in exchange of support of Indians, full-fledged support of Indians, we are going to give dominion status. Do you think at this stage, Indian nationalist leaders would agree on dominion status? No, right? So this is what exactly happened. So you read about it in modern history, right? Later, Congress put forth his own demand, ki theek hai, we are going to support you, but this is what we need as World War II ends. Now, this dominion status demand was rejected by Indians. Then we had this Cripps mission, 1942. Dominion status to India, protection of minorities, setting up Constituent Assembly with representatives from princely states, British provinces, provisions of British provinces to have their own constitution they want. So these kind of ideas actually were proposed in Cripps mission, and it was a big fail. We are talking about 1942. तब तक तो महात्मा गांधी जी ने भी बोल दिया था do or die, right? Quit India movement. So again, a question for you. Now, India Independence Act, where we had a tryst with the destiny of India, as our first Prime Minister, Mr. Jawaharlal Nehru, says in Discovery of India's book. So it declared India as independent and sovereign state. From legal standpoint, you should know that after this India Independence Act, now Constituent Assembly, which was already made, was given the status that, okay, this Constituent Assembly will be responsible for making constitution as well as work as Parliament of India. That's why, my friends, when the same Constituent Assembly was sitting for discussing the constitution, it was presided by Dr. Rajendra Prasad as the president of Constituent Assembly. But when same Constituent Assembly was working as Parliament, at that point of time, Mr. G.V. Mavlankar was heading it. Now, the keeping facts aside, partition of India happened. There was creation of Pakistan. This position of Secretary of State for India got abolished, and this title Viceroy, this was also removed, because Viceroy means representative of Crown. And why would we have representative of Crown if we are going to get independence after this act? So it abolished the office of Viceroy and provided for a Governor General who was to be appointed by the British King for the dominion of cabinet, because abhi ek stopgap solution chal raha tha. Now it empowered the constituent assemblies. Abhi maine aapko bataya, India and Pakistan, they were given this sovereignty to decide the constitution of India as well as constitution of Pakistan. Now, governance of each dominion was to conducted based on Government of India Act 1935, as I told you, right? British monarch could no longer ask for bills, right? Okay, you have to give me the bill and then I'm going to turn into act. No, we are not going to. The crown rule ends here. Ab wo time gaya, right? Now, Governor General of the dominions were made to act and aid or the advice of the council. And then we had our last Governor General, Mr. Mountbatten, right? At the stroke of midnight, British rule came to end in India. Lord Mountbatten became the first Governor General of the new Dominion of India, because as Lord Mountbatten gave this charge of Governor General of India to C. Rajagopalachari, then this was final, you can say, exit of Britishers. The Constituent Assembly of India formed in 1946 and became the Parliament of Indian Dominion. And after the enactment of Constitution, we were sovereign, socialist, socialist word came later, secular, democratic, republic, right? Now, coming to the story of Indian Constitution. So this constant assembly, this concept was agreed upon based on cabinet mission plan. The plan which was actually circulated during this May of 1946. And by the time of July, certain provisions of this cabinet mission plan, which talked about how the members of this constant assembly are going to be elected and nominated. The plan was mentioning the process, and that election even got completed by July 1946. Take a look over the speed, execution, right? So I use two words here, and UPSC also made a statement in prelims 2016. So Constituent Assembly members, some were elected and others were nominated. Now, elected ones. These elected were from British provinces. So in British provinces, there were provincial assemblies already there, right? Provincial assemblies, for example, we have state legislature, right, at the level of state. So similarly, provincial assemblies at the level of provinces. The members of these provincial assemblies were not directly elected by all the people. Means concept of universal adult franchise was not there. They were directly elected, but by limited franchise. As I told in the previous session, only around 10% Indians were having this right to vote. So it means if these are provincial assembly and these are seats of these members and there is presiding officer and these are the people. So now only few people, say 10% people, were getting power to vote and decide who are going to be member of this provincial assembly, right? Various provincial assemblies. Now, members of these provincial assemblies, these people, these fellows who are sitting here, now these people are going to decide who are going to be member of Constituent Assembly from their provincial, from their provinces. It means from their provincial assembly. अब इसमें भी ये भी हो सकता है that they themselves want to nominate themselves, or you can say they themselves want to actually participate in the election, और ऐसा भी हो सकता है, this can also be possible that they want to elect someone other, right? This is also possible. Please understand this difference. Sometimes these nuances are not clearly mentioned in your Lakshmikant, but UPSC can make actually you can say question on these nuances. So I'm repeating again, these are the total people in this particular province. Consider United Province, right, which we call now Uttar Pradesh. Now only 10% people were having power to vote. Now they voted these members. So this was direct election of these people, right? So that is why this was direct election. But when it comes to membership in Constituent Assembly, this was indirect election. Indirect election. Why indirect election? Because member in Constituent Assembly were not getting elected by these people. These people elected these, and now these provincial members were participating in election of members who are going to represent their province in Constituent Assembly, right? And what was the method which was used? It was proportional representation. Proportional representation. And some of you might think, sir, what is this proportional representation? It is always confusing. No. There's no confusion as such. Proportional, the word represents when it comes to Constituent Assembly, the whole Constituent Assembly, we need to ensure that we are fair with every province. And for that, we have made this method, okay, on that we are going to have this election, and in this election, how many seats can be actually filled by a particular province? This will be based on population. Since number of seats allocated to this particular province, say this province is UP, United Province. So UP को कितनी सीट मिलेंगी? It will be decided on the basis of population of UP. If there is another province which has less population than UP, then definitely that particular may have only 2 seats in Constituent Assembly, right? So it means direct election of in this provincial assembly, okay, and from there indirect election in constituent assembly. And why proportional representation? Because seats allocated in constituent assembly are based on population you have, and when I say population, this will be total population, right? Not just population who are actually allowed to vote. Okay, I hope this is clear. Now, as you can say, it was formulated to what was the purpose of Constituent Assembly? Purpose was that we want to make a constitution which can be used to facilitate the power transfer, sovereign power transfer. Because now we want our sovereign government. We want to get independent. So how this can be done? This job was given to Constituent Assembly. Okay. Now, so this Constituent Assembly had in total 12 sessions, and there are many surprising facts which you are going to see in this lecture. When I use the word Constituent Assembly, what comes into your mind? There is one body and there are some fixed members. There were some fixed members. As you must have seen some data in composition part of Constituent Assembly, right? But my friends, the idea of cabinet mission plan was not so direct. Okay, first of all, there was no fixed membership in Constituent Assembly at a particular point of time. What does it mean? It means that yes, seats were there, seats were fixed, but when it comes to membership, membership was not fixed. It means many people resigned, some got died, and some who were not getting nominated from a princely state because princely state was saying no, we are not going to be part of Constituent Assembly. Then they later actually started sending their representatives in Constituent Assembly. So at one particular time, you cannot say that there was a fixed membership. Allocation of seat was there. Allocation was fixed, you can say, but membership kept on changing, right? So these were the 12 sessions. Now, demand. So for the first time, the demand for Constituent Assembly was raised by Mr. M.N. Roy. So when you open your Lakshmikant, the first page itself of this chapter, so you find a word, radical democratism. So this idea of radical democratism comes from the idea which M.N. Roy was supporting. He wanted to bring radical democracy in India. And for that, he was demanding, we should have a separate Constituent Assembly of our own. Now, the idea of radical democracy supports that there should be maximum equality and maximum liberty in upcoming India. We should devise a system where there is maximum liberty and maximum equality. So, when it comes to M.N. Roy, he was a communist who once was against Congress. Then he was part of Congress. Then he went out of Congress, and then he started his own party, and he started supporting radical humanism, and within that, radical democracy. But we are going to take this up in some other time, other lecture. You can put it in comments if you want this discussion to happen with you here. But today our focus is on making of Indian Constitution. Now, in 1935, Indian National Congress demand to frame Constituent Assembly, our own Constituent Assembly. In 1938, Jawaharlal Nehru, he raised this point that there should be free and fair, no external influence when it comes to making our constitution. It was 1938. And at that point of time, Nehruji was saying that we want members of Constituent Assembly to be elected through universal adult franchise. It means every adult person registered as voter in Indian territory will be allowed to participate in voting for members of Constituent Assembly. Now, why he was supporting this? Because he was well aware with the idea of constitution. As I told you, it's a contract. People coming together and agreeing, yes, we want these laws. So in this way, he was thinking that people will appoint some representatives, and now these representatives on behalf of people will participate in constitution framing process. This constitution will have more legitimacy in the eyes of people, because people will think, we have participated in constitution making process. But although this universal adult franchise-based election of the Constituent Assembly members never happened due to practical reasons, as I told you, election happened from provincial assemblies, and there was another idea, nomination. That nomination happened through princely states. It means there was no election to the member for the members who are going to be part of Constituent Assembly from princely state directly. Whoever is the authority there, they were allowed to nominate their person in Constituent Assembly. That's why I use two words. Now, August offer. We also talked about this in brief in the previous session. Since it is connected to Constituent Assembly, just take a look. In 1940, we saw war in Europe. Hitler was all set to attack Britain. And at that point of time, Britain, without taking consent from Indians, declared that now Indians are going to be used, or you can say participate in World War II with British forces. So on this point, many Congress leaders were furious. Why our consent was not taken? And they denied their support. At that point of time, Britishers wanted that it is point of time where you should support Britishers, because otherwise fascist forces will actually claim the land. So at that time, Indian Congress made two demands. One, complete independence for India after this war ends. Second, formation of interim government during war. When I say interim government, interim means short-term government. And this short-term government will have Indians on key positions. That was the demand. As a response to that, British Viceroy Lincoln, he agreed on certain points, and the offer he put forward was considered as August's offer. But he was using the word dominion, that dominion status will be given. And at that point of time, Indian National Congress and many other parties rejected this offer. After that, we saw Cripps mission coming in. So later, India accepted August's offer, as Britishers accepted the demand for independence and independent constitution after the war. This point also be kept in your mind, because later Indian National Congress, they agreed. Okay? And why they agreed? They thought it can be the first step. Later we can also claim sovereignty, right? And you should also, at this point of time, I would like to ask you a question. Just search about the status of Republic of Canada and Australia. Can you call Canadian system or Canadian state, you can say nation, as an you can say a sovereign nation? Can you call it sovereign? So what kind of system they have? Because they have the crown as their head of state, means British crown as their head of state. So same idea was proposed by Lillingo. Later we accepted कि ठीक है हम देखेंगे इसको. But times changed later, and that's why we rejected. नहीं, अब dominion नहीं. We need sovereignty. Now, a draft proposal on framing of independent constitution after the war, but it was rejected by Muslim League, because Muslim League wanted separate Constituent Assembly for two nations. Now, what happened? Now came Cabinet Mission. Now, the scheme Cabinet Mission proposed before Indian National Congress, Muslim League and some other parties, it was accepted. Although principally they wanted that there should be separate Constituent Assembly, but the scheme they proposed, the method they proposed, it was agreed. So INC and Muslim League both agreed. Cripps, Patrick Lawrence and A.V. Alexander were part of this. Please remember these names, because UPSC has asked question on these facts. Now, some of you might be wondering, what scheme was there in Cabinet Mission plan that even Muslim League agreed to be part of one Constituent Assembly? Although it was rejected earlier, right, in Cripps. So this was the scheme. It means there will be one Constituent Assembly, but within one Constituent Assembly, there will be 3 sections. This information is not there in your Lakshmikant, but you should know about it. Punjab and Northwest, Bengal and Assam, and rest of India, 3 sections within one Constituent Assembly. Okay. Now, take a look, Punjab and Northwest. Now, if you take into mind, just think, Punjab and Northwest and Bengal and Assam, the provincial assemblies in these areas were having majority of Muslim League. So Muslim League thought, okay, so if these are the separate sections within this Constituent Assembly and members of Muslim League, they will actually be the key players in appointing people who are going to be part of these sections. So that is why they can drive the provisions on their own. Means they will have, major say. That was the idea. But later, Muslim League also, boycotted this particular Constituent Assembly. They rejected this because at that point of time, Muhammad Ali Jinnah was, on fire. He was, spearheading a major campaign that there should be two nations. And later we know that how this two nation theory was accepted. So originally the idea was having these three sections, but this three section based Constituent Assembly never worked. Okay, so this one rest of India. So actually there was no rest of India. There was one Constituent Assembly for all of India. So actually this happened, but this was part of the scheme. Okay, you should know about it. Now, composition of Constituent Assembly. So constitution under this cabinet mission plan. So this composition was constituted under cabinet mission plan. They agreed 389 members honge, 296 British India and 93 princely state. When I say British India, it means these will be representing the provinces, right? And they will be elected and they will be nominated by princely states. Now take a look. The assembly was to have proportional representation, as I told you, right? Proportional representation, it means based on population, we are going to ensure that seats are allocated so that our Constituent Assembly composition is fair and more representative. Okay. Now, as I told you, in May 1946, cabinet mission plan got circulated and it was accepted, and in July 1946, elections were done. So this process was expedited under the supervision of Reforms Office, and this Reforms Office was working under Viceroy Office. Okay, please remember this fact. UPSC may play around these lines, and this particular information is not there in Lakshmikant. Now each province and princely state was allotted in proportion to their respective population. I've already given you example. Roughly one seat allocated every million population. One seat for every million population. Just remember the metrics. Now, seats allocated to each British province were to be decided principally into three communities. Now, what is this? Consider United Province. In United Province, you have different members of provincial legislative assemblies, right? They are directly elected by the people by limited franchise, right? Now, my friends, take a look. Or just remember what we were discussing in historical background of Indian Constitution. I talked to you about concept of separate electorate, right? Now, in cabinet mission plan, they said we are going to divide the representation in this Constituent Assembly into three heads. It means Muslims, Sikhs and general. So who are going to be general? Except Muslims and Sikhs. Right? Obviously, you would think, yeah, Muslim League would accept this, right? The representatives of each community were to be elected by members of that community in the provincial legislative assembly. जैसे आपको बताया, in United Province, UP, you have Sikhs, Muslims, and other general, right? Now, the Muslim community members who are part of this provincial legislative assembly, they are going to vote for who is going to be their representative, means representative from UP as well as Muslim in Constituent Assembly, who will be representative of Sikhs from this particular provincial legislative assembly in Constituent Assembly, and similarly from general. So this was the categorization. Okay. Now, voting was to be by the method of proportional representation by means of single transferable vote. So this method is also later adopted in Indian Constitution. We use it, for example, President, right? So in President chapter, I'm going to conduct the proper election here. Okay, and I'm going to tell you in detail how this proportional representation with single transferable vote works. Okay. Now, the representatives of princely states were to be nominated, already told you. that nomination from princely state and from provincial legislative assembly election. And how is this election? I've just told you. Okay. Now can we all agree on this point that Constituent Assembly composition is partly elected and partly nominated? Right? Elected from provincial legislative assembly, nominated from princely states. Right? Now the members were to be indirectly elected by the members of the provincial assemblies, as I told you. Why indirectly? Because people were not directly, these people in United Province were not directly electing member in Constituent Assembly. They have already elected these provincial assembly members, and now these provincial assembly members are electing who is going to be part of Constituent Assembly from their area, from their category, right? Who themselves were to be elected on a limited franchise. Already given you the example. Right? Now, election July-August 1946, Indian National Congress won 208 seats, Muslim League won 73 seats. Now, many people have this story in mind that later, since Muslim League boycotted this Constituent Assembly, so their members did not participate, and later we had this two-nation theory successful, and that is why creation of Pakistan happened, and this Muslim League members moved to Pakistan. This is what you know. Right? But this is not the complete truth. There were some Muslim League members who chose to remain in India. Yes. And they were part of Constituent Assembly, but they got this seat on the basis of Muslim League seat. Right? For example, from United Province. Okay, this is an interesting information that some people who were in Constituent Assembly were there. They chose to be there. And they were from Muslim League. Okay. So when I'm giving certain information which is not in Lakshmikant, all the sources I share in my Telegram group, which you know, Shashank Tyagi for you can search. Now, the 93 seats allocated to princely states were not filled, as most of the princely states were not agreeing to this scheme of Constituent Assembly. They wanted to claim their power. Right, and decided to step away from Constituent Assembly. Although slowly, many princely states started sending their representatives, but Hyderabad state did not send even a single member in Constituent Assembly till the last point of time. Comprised representatives of all sections of Indian society. Hindus were there, Muslims were there, Sikhs, Parsis, Anglo-Indian, Indian Christians, SCs, STs, including women. Now, so by this particular last line, I hope it is quite clear to you that our Constituent Assembly were truly representative in nature. There was no one left behind. Now, some of you might be thinking, sir, since in composition, 208 seats were of Indian National Congress. It means the way Indian National Congress wanted to mold our constitution, that's how Indian constitution must have got molded. But the point is, they adopted the method of consensus in Constituent Assembly debate. It was not pure majority basis making of Indian constitution, and this decision was taken by the foresight of our constitution framers, that if majority voting is the basis of including certain provision of Indian constitution, then it can be a question on the legitimacy of our constitution in future, right? And that is why consensus was taken. There were a lot of deliberation, discussion. Now, working of the Constituent Assembly. So first meeting happened on December 9, 1946, and at that point of time, considering the seniority, Dr. Sachidanand Sinha was declared as interim president of this Constituent Assembly. And why you need a president? Because you have to ensure a proper functioning. Who is going to tell that this is how we are going to manage the working of Constituent Assembly? You always need a presiding officer in such a scheme so that proper functioning can be ensured. Now, as I told you, Muslim League boycotted. Now, December 11, Dr. Rajendra Prasad and H.C. Mukherjee. Dr. Rajendra Prasad as president got elected and H.C. Mukherjee as vice president. You should keep in mind, this is a basic fact, that Gandhiji was not part of Constituent Assembly. Now, take a look over these questions. Fast. It's the basic one. बचपन में आप जब क्रिकेट खेलते थे, so first ball used to be a trial ball, na? So this is a trial ball. All of you know, 9 December, right? Now, second question. Which of the following provisions of the Indian Constitution were immediate effect on 26 November 1949? as our constitution got finalized. It means the word used is anointed. On 26 November 1949, certain provisions were actually applied on this date, whereas the full-fledged constitution got enacted on 26 January 1950. We actually agreed on this date because of the Poon Swaraj resolution, which actually got raised on 26 January. Now, take a look. Citizenship, election, emergency provision, federal structure. Answer is citizenship provision, election, and there are other provisions which were associated with provisional parliament. Okay, so answer would be 1 and 3. Okay, now objective resolution, a famous speech and the document which is connected to the start of the working of Constituent Assembly. As the word suggests, objective. The purpose of this speech and this particular document was to bring a speech before this Constituent Assembly telling them what we want to achieve. These are the principles. To ensure these principles, we need certain, you can say, provisions in the articles of Indian Constitution. So the speech was given by Mr. Jawaharlal Nehru, and this resolution was moved on 13 December 1946. Those who are wondering, what is this resolution? So resolution comes as a proposal. A particular member in Constituent Assembly or in legislature, they will stand up by taking permission from the presiding officer. Sir, we want to have this resolution. So presiding officer will say, okay, theek hai, start ho jao. So they will present that honorable members of the Constituent Assembly, I think that all powers, we should consider this, that all powers of the Constitution of India are going to be derived from people of India. Independent and sovereign India is what our Constitution is going to give. Promotion of peace and welfare, safeguard minority, tribal, backward sections. Freedom of thought and expression is going to be one critical feature of our Constitution. Justice, social, political, economic, where our Constitution is going to ensure for the people of India. So he gave the speech and he said, I move this resolution. Now there will be a process in which people will participate and they say, yes, we also agree, yay, we also agree. So when majority of the people agree, yes, this should be the objective resolution of Constituent Assembly, it means most of the people have agreed, majority of the people have agreed, yes, that these are going to be the fundamental features of our Constitution. This objective resolution later became Preamble of India, which gives us the philosophy of Indian Constitution, right? Now, 6 princely states became part of Assembly, which initially stayed away. Now, changes after Indian Independence Act 1947. The first major change. It changed the stature of Constituent Assembly itself. For the first time, Constituent Assembly was declared as sovereign. This act was passed in British Parliament. And now, British Parliament said, before this, what was happening? That before convening any session of this Constituent Assembly, they used to take permission from Britain. But now, in this 1947, they are declaring that now this Constituent Assembly is sovereign in itself. It means now no permission need to be taken from Britain, right? And this Constituent Assembly is sovereign to make Indian Constitution as well as work as Parliament of India. Parliament of India. So some of you might be thinking, why we need Parliament of India? We needed Parliament of India because you need, on day-to-day basis, you need ancillary law, supportive law, right? And these laws can be, these bills can be discussed and can be made law in this Constituent Assembly when it is going to work as Parliament of India. So when Constituent Assembly was working just for the making of Indian Constitution, at that time it was being headed by Dr. Rajendra Prasad. But when same Constituent Assembly members are sitting together as a parliament, then this particular assembly was headed by Mr. G.V. Mavlankar. Now, became fully sovereign, became legislative body, it became responsible to frame constitution whenever the assembly worked, the constitution body. Dr. Rajendra Prasad, I told you, now Muslim League withdrew from the assembly and it reduced the total strength of the assembly to 299 from 389. Basic fact, the strength Indian provinces reduced 299 to 296. from 299 from 296, and that princely states 70 to 93. These are basic facts. Now, another question for you that you have to attempt and you have to answer in comments. I'm going to upload this PDF in Telegram. You can find, and you can find answers hidden in this part of PDF. Okay, when you are going to see the PDF, answer will be hidden in this part. Okay. Now, by this question, I want to tell you one type of question is based on membership of a particular committee. Okay, committee, because Constituent Assembly was not working like this is a Constituent Assembly and these are the members sitting and now all of them are discussing same point, and now they are going to decide, okay, we are agreeing on point number 1, let's add into Indian Constitution. This is not how Indian Constitution framing was being done. So what happened, that Constituent Assembly itself got organized into several committees, and these committees were given special job that you have to work on this particular issue, you have to work on this particular issue. Now these particular committees used to present their research report, their discussion, deliberation, their final output before Constituent Assembly. Then Constituent Assembly would discuss on that, and based on this discussion, consensus building, then it was agreed ki okay, now we can add into draft constitution, right? Although there was second reading, there was third reading, so that in future if some people have some arguments to add on something which agreed upon earlier, then you can also add in the second reading. So such kind of deliberation was happening during constitution making process. So my friends, it was not a you can say copy paste work, right? A lot of deliberation discussion was going on. Now first president Dr. Rajendra Prasad, all of you know. Now drafting committee, UPSC has asked question on members of drafting committee. So this is the list of members of drafting committee, and the chairman was Dr. B.R. Ambedkar, right, who is also known as father of Indian Constitution due to the kind of efforts, contribution he has made to Indian Constitution. So you can remember, this particular committee by making some mnemonic. As I told you, there are only two ways your memory is going to register some information and reproduce easily in exam. That is, if you have, a lot of interest in that particular information. For example, you can easily remember your first movie or first acts of excitement which you have done in your life. You can easily recall them, right? Interest. So have this kind of interest in your subject. This is one way. Second is revision. When you keep on revising on a particular interval, you practice, get this information and use this in MCQ. That is a way to register more and more information in your memory and reproduce in exam, right? So I was saying interest. So interest can be produced by actually making some mnemonics. Some funny mnemonics can be used. Toppers use these methods so that they can organize information in their head. Gopal Krishna Munshi was playing TT with Sayyad Rao. So Gopal Krishna Munshi was part of drafting committee, and when they were actually, they used to get tired of this discussion deliberation, so they had this TT table within the conference room, and they used to play TT, and who were playing Gopal Krishna Munshi and Sayyad Rao. So these keywords means Gopal. So they will give you these you can say options on the names, and you can easily recollect. Gopal Swami Iyer, Krishna, Munshi, right? So this is a hint you can use. Now, 26 November 1949. Now, Constitution was passed containing 394 articles and 8 schedules. Yes, but final election happened in 26 January 1950, right? Now, another question for you. This is also a, very direct kind of question, but these kind of questions are also asked. Basic facts. Who calligraphed the Indian Constitution? Yes. In comments. Now, this is information on this. Now, timeline of formation of Constitution of India. So this is a quick timeline so that you can recollect the information, revise it easily, right? If UPSC makes 3 statement, 4 statement and says that arrange the following in exact chronological order of making of Indian Constitution. Then you can remember on 6th December 1946, formation of Constituent Assembly in accordance with the French practice. In 1946, 9 December, we had the first meeting. 11 December, we had this President appointed Dr. Rajendra Prasad. This information shared with you. 13 December, objective resolution already discussed. 22nd objective resolution was anonymously adopted. So at this point of time, it was proposed, discussed, and it was adopted. And please remember, objective resolution was not adopted on the basis of majority vote. I gave you example because this is how resolutions work in our legislative system. But as Constituent Assembly was majorly focusing on building consensus, so it was unanimously adopted. Everyone agreed on that. Okay. 22nd July 1947, Indian national flag was adopted. Then 15 August 1947 achieved independence, split of dominion of India and dominion of Pakistan. My friends, dominion word is being used because still the Constitution of India has to be enacted, and this enactment we declared ourselves as sovereign, right? That is why dominion word is used. 29 August 1947, drafting committee appointed with Dr. B.R. Ambedkar as the chairman. You can see in 1947, Dr. Ambedkar and drafting committee is coming into picture formally. 16 July, you see along with Harind Komar, V.V. Krishnan presided the Constituent Assembly. 26 November 1949, we have Constitution of India, and this adopted anointment ceremony, we can say that the word is anointment. 24 January 1950, you have last meeting of the Assembly, Constitution of India, all signed, accepted with 395 articles, 8 scheduled, 22 parts. Now 26 January 1950, Constitution of India came into force. It took 2 years, 11 months, 18 days at a total expenditure of 6.4 million to finish it. So this is the basic chronology, right? Go through this 2 times and it will be set in your mind. Now, criticism of Constituent Assembly. First criticism is raised that it was not truly representative, not a representative body, because from princely states, it was based on nomination. The members were being nominated by the ruler of that princely state. When it comes to provincial assemblies, so there was indirect election, and when it comes to these members of provincial assembly, they themselves were getting elected by 10% of the people. Limited franchise was there. So how can this Constituent Assembly represent the whole of India if the members were not coming? They were not coming from the voice of the people of India. So this is a criticism which is raised, that it does not reflect the verdict of the people. But you can say that on practical grounds, you could not exercise such a big election within that short period which was available with us, right? So that is why it was done. Not a sovereign body, because it was formed and it was based on cabinet mission plan. And when it comes to its meetings, before the enactment of India Independence Act 1947, for the meetings even we had to take permission from British. Took great time in framing the Constitution. As I told you, 2 years, 11 months, 18 days. When it comes to American Constitution, it took only 4 months. But we have some arguments because due to the complexity of India, geography, diversity, right, the challenges we were having, that is why more time was taken, right? And our Constitution is way elaborate than the Constitution of America, Bill of Rights. It was dominated by Congress. This is one criticism. As I told you, that dominated by Congress, but it was based on consensus building. Domination of lawyers, politicians, as our Jennings say about Indian Constitution, that it is lawyers' paradise. Common individual, common Indian would be, it would be difficult for a common Indian to understand Indian Constitution. Criticism says that Constitution of a country should be such that even a common man can understand that, right? So this is criticism. Dominated by Hindus, this was another criticism, but you should know that representation was there across gender, when I say gender, it means women were there. Representation across caste was there, means caste means SCs, STs was the criteria of ensuring representation. Religious based representation was also ensured. Salient features of Indian Constitution. So let's take first step. Indian Constitution is written Constitution. That is one feature. But what is the difference between written and unwritten Constitution? So you should not think that unwritten Constitution is not written somewhere. It is simply that the difference is that in case of written constitution, there is a particular codified form. It means one document declaring that yes, this is the fundamental rule book. But when it comes to unwritten constitution, series of laws are time to time declared as part of constitution. Like example, Britain. So you can say that there, in case of written constitution, these rules are thought during the process of framing, right? And there, it evolves with time. Okay, both can be considered rigid and flexible based on the ways amendment procedures are made there, right? When it comes to this unwritten constitution, since parliament is having power to declare which particular law is going to be considered as part of constitution, that is why it is seen that parliament is supreme where unwritten constitution is followed. For example, Britain. In Britain, parliamentary supremacy is there. But when it comes to written constitution, because one rule book is considered as fundamental, that is why constitutional supremacy is there, right? Parliament has to adhere to the basic principles mentioned in constitution, right? So here we see judiciary has limited power, like in case of Britain. But here we see judiciary has considerable power. Why? Because judiciary, Supreme Court in this case example, is considered as ultimate interpreter of constitution. And interpretation of constitution becomes important because India is having constitutional supremacy. All the institutions should work as per constitution. Now, some of you might be having this question in mind. Oh, since Supreme Court is having more power in comparison to legislature and executive, what happens if judiciary itself trespasses some provisions of constitution? What is going to happen then? My friends, Supreme Court, say highest, you can say level of judiciary, it is an office. There is a bench of judges. If they pronounce a judgment at some point of time, let's suppose, and which you are saying that trespasses some core principle of constitution, then my friend, these bench of judges are not Supreme Court. Supreme Court is an institution which is bound by certain duties. You can file a review petition which may be heard by other bench, and other bench may have different opinion, and the different opinion will prevail then. So it means constitution will prevail. Okay. So for example, you can take here unwritten constitution Britain, written constitution India, USA. Now, original constitution had 395 articles, 8 schedule, basic facts. Now, why our constitution is so lengthy? One is geographical factor. Diversity is there, right? Diversity is there, so needs, challenges will be different. Historical factors are also there. Single constitution for center as well as state. But there are nations where states have different constitution. But in case of India, there is one constitution applicable for center as well as state. In our constitution, there is a dedicated portion for union, another dedicated portion for states, right? And special provisions are also there with respect to the challenges faced by states. For example, Article 371, right? Constituent Assembly dominated by legal luminaries. And if Constituent Assembly was dominated by legal luminaries, they wanted constitution should be as elaborate as possible. Right? The efforts was that this constitution should fulfill the aspirations of Indian people, and there should be less, minimum possible ambiguity when it comes to articles in Indian constitution. Although there's always scope of interpretation when we talk about law, and that is why our Jennings says that Indian constitution is lawyer's paradise. Now, going ahead, Indian constitution has detailed fundamental principles of governance and administrative principles, means how our nation is going to run. This is a picture of our preamble. Now, drawn from various sources, this is another feature. But can you say that Indian constitution has copy-pasted provisions from across the world? No. Many people have this question, oh, why we have not created original constitution? Why we have different sources? The reason is, my friend, you are building constitution. It means you are going to mention various processes, institutions, powers. And these insights develop with time in political theory, from where these provisions are taken. So if some methods have already been tested somewhere and proved success, and if some methods have already been tested somewhere and they proved failure, don't you think we should learn from them? And we should have comparative analysis how these particular principles may be applicable in Indian context. That is why Indian Constitution has been framed after ransacking. B.R. Ambedkar ji uses the word ransacking, all the known constitution of the world. So for example, from United States, we took these prominent provisions: Preamble, written constitution, federal structure of the government, fundamental right, function of president, vice president, independence of judiciary, judicial review, removal of Supreme Court, High Court, judges. Important. These particular, sources point, question has been asked. For example, which of the following provisions of Indian Constitution are not taken from US Constitution? And then they will have 4 options, and one option would be, say, nominal head president. So that statement would be wrong, because nominal head as president is taken from UK, right? Because there, head of the state is queen, but queen is nominal. In case of India, head of the state is president and president is nominal. But when it comes to United States, head of the state is president and president is real head, right? Means real power resides with president there. But in case of India, president is nominal head. Designation of prime minister is there. For example, in case of Britain, prime minister is having major power. But in case of US, they don't have any post for prime minister. Cabinet system of ministers, parliamentary form of government we have taken from UK. Now bicameralism, speaker in Lok Sabha, single citizenship. My friends, here we are talking about features of Indian Constitution. That is why we need to consider what are the sources. But when we are going to talk about parliamentary system in detail, when we are going to start parliament chapter, then we need to identify the difference between British parliamentary system and Indian parliamentary system, right? If question is asking which of the following statements represent the parliamentary system of India, and if that one particular statement is a feature of parliamentary system, but that feature is not present in Indian parliamentary system, then you need to have clarity between how this concept of parliament evolved, what are the features of parliament, although we are going to discuss today as well, because this is also a feature of Indian Constitution. But when we are going to talk about parliament, then that we are going to talk about this model in detail. Now single citizenship, we are going to talk about this when we talk about this chapter, citizenship, speaker in Lok Sabha. But you should remember that these are the portions taken: concurrent list, language of the preamble, provisions regarding commerce, trade, Australia, Canada. Similarly, these are facts. Idea of federation with strong center, like Canada is having. But same is not the case when it comes to USA. Distribution of power between center and state, treasury powers with center. Ireland, directive principle state policy, election of president, nomination of members in Raj Sabha. Japan, procedure established by law, important component of our constitution, especially this phrase mentioned in Article 21. Now Russia, 5-year plan, fundamental duties, which were later added, right? Weimar Constitution, Germany, suspension of fundamental rights during emergency. Now, our constitution is a blend of rigidity as well as flexibility. Why I'm saying that? Because our constitution in Article 368 mentions procedure to amend constitution, which requires special majority. But we also have certain areas where constitution can be amended by simple majority, like if you have to create the state, separate state, if you have to bifurcate the state, for example Article 3, Article 4. So it means our constitution has given enough flexibility also. You should think why our framers of the constitution thought of having a mix of flexibility and rigidity. The reason is, if you make constitution amendment too flexible, then upcoming governments may abuse it, may play with the basic principles of Indian Constitution, right? And that is why some rigidity need to be added to, right? Although there is Supreme Court, and especially after Kesavananda Bharati case 1973, it is also quite clear, although Article 368 gives power to Parliament to amend Constitution, but this power is not absolute. You cannot play around, you can say change the basic structure of Indian Constitution. And when Parliament asks, sir, what is this basic structure of Indian Constitution on which our power to amend Constitution are limited? Then Supreme Court said that we are going to tell on case-to-case basis. So it means ball is in the court of Supreme Court to decide what is going to be considered as basic structure of Indian Constitution. So this scope actually is possible because judiciary was given this guardian role, right? So Constitution of India is neither rigid nor flexible. It is synthesis of both. Flexibility was given so that aspirations of the future generations can be met. क्योंकि अगर आपने rigid ज़्यादा बना दिया Constitution and demand in the changes, demand related to, you can say, if there are new challenges in the political system in future, and people are demanding certain changes in Constitution, but the hands of that particular government is tied. They cannot make that change. Don't you think it will reduce the legitimacy of Constitution? So that is why if you have to gain the legitimacy, then you have to be flexible also, rigid and flexibility both. Federal system with unitary feature. But you should remember, in Indian Constitution, the word federation is not used. Article 1 says union of states. It means Indian federation is not the result of agreement by the states. Not a state has the right to secede from the federation, right? So on this, there are certain phrases on which questions are asked. For example, quasi-federal. Who said? K.C. Vere. Quasi-federal means a mix of unitary as well as federal. Okay, when I say federal, so it means this is center and these are state. So center has certain areas in which center is having power. State is also having certain areas in which state is having power. You should also know that this concept of federal system actually evolved with demand for giving some power to the smaller unit, which is part of that union. From there, this concept of federal emerged. So why this emerged? Because it may be possible that small administrative unit might be having certain challenges which are different from other smaller unit, and that is why this smaller unit should have power to regulate the affairs of this area. So from there, this concept of federal in polity emerged, and we took this in polity as it was already there during the British administration, right? So federal system of government, it means there is division of power between center and state. We have Schedule 7, union list, state list. Indian government also contains many unitary. Indian Constitution has unitary feature as well. For example, if I say state list is mentioned in Schedule 7, but it is not like that center cannot make law with regard to state list. There is scope also. If Rajya Sabha passes the resolution in this regard, that this is a matter of national importance, then Parliament can make law in case of state list also. And with regard to this Article 356 use, when president rule is imposed in a state, so there also it represents this unitary feature. So we are talking about unitary feature, but what is unitary feature? When power shifts towards center. And you should think, why our constitution framers give more power to center? Why not equal power to state? The simple reason is there were chances of secession. There was differences, secessionist movement, possibility of secessionist movement, and we could not actually let it happen. And that is why for securing integrity, for territorial integrity, this power was tilted towards unitary feature, yani ki power was given more to the center. Now quasi-federal, apart from this, Morris Jones said it is bargaining federalism, because more power is with center. So with respect to finances also, for example, Finance Commission is there, and Finance Commission is a constitutional body which actually gives government the formula to divide resources between the revenue which government has collected between different states and center. Now this formula is given by Finance Commission. It is recommendatory in nature. It is actually prerogative of union government whether to accept it or reject it. Now the point is, which state is going to be given more funds? Who is going to decide? Center is going to decide. And there comes the play regarding bargaining federalism. So those states who are in good books of the center, majorly those states who have the same party ruling, which is ruling at the center. So in this case, state, center relations turn into bargaining aspects. Similarly, you have cooperative federalism. As Grenville Austin, it means cooperation is the essence of policy formation at the level of center as well. And Modi government has primarily pushed this idea of cooperative federalism. For example, Niti Aayog, another example, GST Council, where state cooperation is considered necessary in key decision making. Now, Constitution of India is neither purely federal nor purely unitary. It is combination of both. in the views of D.D. Basu? This is a cakewalk question. The word is cooperative federalism. So who used this word cooperative federalism? Abhi आपको बताया, just told you, Grenville Austin, right? So this is just an example that this kind of question are also asked. Now, parliamentary form of government. This is another feature. Now the point is, what is parliamentary form of government? One, there should be nominal as well as real head. For example, nominal head in case of India is president and real head is prime minister. In case of Britain, nominal head queen, and when it comes to real head prime minister. Executive is part of legislature. It means those members who are part of this legislature, some of them will be part of Council of Minister. So it means there is overlap between legislature and Council of Minister, right? But same is not true with respect to USA. In USA's case, there is presidential form of government, and in presidential form of government, there is separation between executive and legislature, and that is why the key officials in Biden's administration, for example, Secretary of State, Secretary of Defense, they are not part of their Senate. Right? But in case of India, take a look on our Council of Ministers. They are either part of Lok Sabha or Raj Sabha. Right? Our constitution says that if there is a minister, then this minister has to become part of either House of Parliament within 6 months from the date he is appointed or she is appointed. Right? So it means this overlap is there. Majority party rule and coalition government means you need to have more than 50% seat, either your party or coalition, means absolute majority is needed in the house, lower house, in Lok Sabha, in order to form the government. Because this government will be considered as legitimate government to rule this particular area. Another feature, collective responsibility. What does it mean? It means Council of Ministers will swim together and sink together. It means this, if say Prime Minister resigns, then this whole Council of Ministers is going to resign. It means they are accountable to Lok Sabha. It means if they loses majority in Lok Sabha, then this particular government stands no chance to be there. Right? Prime Minister as the center of power, although the concept says primus inter pares, it means chief among the same. But the point is, traditionally, it is seen that Prime Minister is more powerful than its other members of the council. Then parliamentary opposition, it is also crucial part of parliament, because parliament is there so that this parliament can function for the betterment of people. And betterment of people can only happen when there is someone to actually challenge this government, to make them accountable. That is why opposition is important. Independent civil service, so that administration have its own independence. Then bicameral legislature, for example Lok Sabha, example Raj Sabha. Now some of you might be wondering, oh, bicameral legislature, how is it connected to parliamentary system? My friends, please understand, I'm using the word parliamentary form of government. Some of you might be considering, oh, parliamentary form of government means parliament, right? Parliament is different from parliamentary form of government. Indian parliament is an example of parliamentary form of government. If I'm making a statement, just tell me what do you think? It is true or false? Indian constitution provide parliamentary form of government at the level of state as well as center. That statement would be true or false? Indian constitution provides parliamentary form of government at the level of state as well as center. The statement would be true or false? Come on, fast. That statement is true, my friends, because parliamentary form of government at the level of state as well, you have nominal real head different, governor as the nominal head, CM as the real head. You have all these, aspects there. Because executive, Council of Ministers at the level of state, overlap with legislature. Right? So parliamentary form of government is present at the level of state as well. Okay? So this is one feature. Okay? Means bicameral legislature. Although it is not necessary that every state should have bicameral legislature, it depends on the framework they are running until now. Right? Now the point is independent and integrated judiciary. Yes, this is also important feature of our constitution. Now, independent, it means independence of judiciary means this judiciary will be having enough power to influence that this nation is being run as per the provisions which are mentioned in our constitution. It should be integrated. For example, this Supreme Court, High Court. So Supreme Court is the apex court, then we have High Court across different states, right? And when it comes to transfers of judges from one High Court to other, who has the role? Supreme Court has the role. When it comes to appointment of judges in High Court, who plays the role? Supreme Court plays the role, right? When it comes to making some interpretation on a particular constitutional aspect, so who plays the role? Supreme Court plays the role, right? And then it is followed by other parts, yani other High Courts as well, right? Now, so that is why Supreme Court is court of record, along with High Court as a court of record. Now, Supreme Court at the top and the state High Courts below it. Another feature, fundamental right. There was a debate going on in Constituent Assembly how many fundamental rights we should add, whether we should go with the word fundamental or we should have another set of words. So we agreed on the word fundamental. Fundamental means they are absolutely necessary. You cannot do anything against it. Means at least we should ensure this. Now, the point is, what was the need of fundamental rights? My friends, rights establish relationship between citizens and the state, means government. Rights give you a surety that at least these are the areas which will be protected, as well as in these areas your progress will be ensured by the government, right? These fundamental rights establish the principle of limited government. It means government cannot trespass up this particular boundary. For example, there was a debate going on in Constituent Assembly that we should have more rights, means although we agreed that, Article 12, Article 235, we are going to include this in Part 3 of Indian Constitution. This was advised by Mr. B.N. Rao, legal advisor to Constituent Assembly, that let's make another Part 4. In that, we are going to ensure adding DPSPs, Directive Principles of State Policy, where there will be socio-economic rights. And since government is not having enough capacity, and political atmosphere is not fit to ensure all economic and social rights, so that is why it was considered, let's do one thing. What can be mandatorily, done by government and which are absolutely necessary, let's put them in fundamental rights, and which we should expect that government should make laws in future, we can put in DPSPs, Directive Principles of State Policy. But you should know that fundamental rights are not sacrosanct, means they are not absolute, they are also conditional. For example, you have right to express, Article 19, subclause 1, subclause A, you have freedom to speak, right, to express. Does it mean that you can express in a way which is actually threat to India's security? Do you think you can express in a way by which a crowd is being instigated and which may create riots? No, you can't. It means our rights are not absolute, our rights are qualified. Fundamental rights are qualified, means they are conditional. Writ jurisdiction are provided in our constitution, for example, Article 32, so that whenever there is threat to your fundamental rights, you can reach out to Supreme Court using Article 32. You can also reach out to High Court using Article 226. And from there, writ means legal order. So Supreme Court and there in 226 High Court can issue a writ so that your fundamental rights can be protected. But my friends, please understand, Article 32 is mentioned in Part 3. Part 3 gives Article 32, and Article 32 gives this power to Supreme Court. You can directly knock the door of Supreme Court. These fundamental rights are being abridged. Then Supreme Court is going to take action for you, right? Apart from this, suspension, Article 19 can be suspended only during external aggression. It means in case of emergency, and when this emergency Article 352 is being enacted on the basis of external aggression, because when we are going to talk about emergency, I'm going to talk about emergency is external, internal. External में भी types हैं, तो वहाँ पर अगर external एग्रेशन की वजह से हो रहा है तो ही आप इमरजेंसी में आर्टिकल 19 को ले सकते हैं, नहीं तो नहीं. और आर्टिकल 20 एंड 21 यू कैन नॉट सस्पेंड, राइट. We are going to talk about these fundamental rights in detail when I'm going to talk about fundamental rights chapter. अभी हम हैं salient features of Indian Constitution. Directive principles of state policy. The word is state policy. It means policy to be made by government. When government try to make some policy, they should consider these principles as directions by Constitution. Although directive principles of state policy are not enforceable, not justiciable in court of law, it is not like if some DPSP is not met, then you can knock the door of Supreme Court, I want this DPSP to be met. No, this cannot happen. This can happen only in case of fundamental right, not in case of DPSP. Okay, so we can divide DPSPs into three parts: socialistic principle, Gandhian principle, liberal intellectual principles. And these are the articles associated with these principles. So socialist principles, where there is a foundation or there is a duty put on the state, or you can say government, that you have to ensure the social well-being. For example, you have to ensure that there is no accumulation of wealth in this particular state, right? There should be equality in society. Those are socialist principles. Gandhian principles emerging from the ideas of Gandhi, for example, Panchayati Raj. Liberal intellectual principles, where focus is on minimizing the restrictions on the people and expanding the choices for the people. We are going to talk in detail when we talk about DPSP. Non-justiciable in nature, you cannot go in court. As I told you, in Mineral case, Supreme Court held that balance between fundamental right and DPSP. My friends, polity has evolved with the debate, who is superior, fundamental rights or DPSP? And this debate in judicial parlance started from the time of Jawaharlal Nehru, right? And then it evolved further. This is a beautiful evolution story of debate between DPSP and fundamental right. It is discussed when we talk about fundamental rights, Article 12 to Article 35. Especially when I'm going to talk about Article 31, 32, 33, 34, 35, there I'm going to bring this debate in front of you, the whole story, different cases, in a simplified manner. Now, fundamental duties, they were not part of original constitution. It was Ms. Indira Gandhi as a Prime Minister gave this charge to Sardar Swaran Singh that advise some fundamental duties for the people, because traditionally the concept of right, when they were added in our constitution, there was this debate, why not add duties also? Because if people of India are going to enjoy right, they should understand the duties also, then only this country is going to run. Then they agreed on this fact. No, our people are the one who are giving this constitution to themselves. This is the first line. And since this is a relation between, constitution establishing a relation between people and state, so it should be considered through these various provisions that people are going to do their duty. People should not be bound to perform a duty, because it may be possible using these provisions, government may start abusing people. Government may become, authoritarian. This was the fear in the mind when this debate was going on. That is why it was not added. But later, on the recommendation of Sardar Swaran Singh Committee, these fundamental duties were added, but they were not made enforceable. This matter was given to Parliament that okay, fundamental duties are mentioned on for implementation of a particular fundamental duty. If Parliament deems fit, Parliament can make a law and even bring punishment if particular fundamental duty is not followed. For example, respecting our flag Tiranga is our fundamental duty or not, right? But punishment is not mentioned in our constitution. For that, we have a flag code, a separate code, right? Recommendation Sardar Swaran Singh Committee, 86 Constitution Amendment 51K was added. It is duty of every parent to send their children from age 6 to 14 years into the schools. India is a secular state. The word secular, where A state does not have any of its official religion. We have the Sarvadharm Sambhav as philosophy. And in case of India, our secular model says that a state can also intervene in a religion for protection of some fundamental rights. So India's model is different from the model followed in Europe. They have clear separation model, but we don't follow clear separation model, right? 42nd Amendment of the Constitution enacted in 1976 added this word in our preamble. Then debate emerged. If Constitution framers themselves did not added the word secular, why Indira Gandhi ji added at the later point of time? Why she was so, you can say pushy about it? Although added through Constitution amendment, it means Parliament has the role. But the point is, they did not added, Constitutional framers did not added because they thought already there are many provisions in our Constitution which themselves represent that India is a secular country. We have a right regarding the freedom of religion ensured through fundamental rights, right? So, and why we should actually give the word secular, right? But she made it that no, we need to put the word secular because preamble provides the core philosophy of Indian Constitution, so it should be applicable. It should be mentioned there. Constitution does not recognize it. It is not actually mixing of religion, state power. We have certain articles, as I told you, already mentioned that Indian Constitution is built on this fabric of secular state. Article 14, equality before law, no discrimination. Article 15 says no discrimination on the basis of religion, race, caste, sex, place of birth. Article 16 says no discrimination when it comes to equal opportunity in terms of public employment, no discrimination on the basis of religion, race, caste, sex, place of birth, descent and resident, two more conditions. 25 says freedom of religion when it comes to practice. You can follow the religion of your choice, practice, profess, propagate, but there are reasonable restrictions. So we are going to talk about these fundamental rights when we deal with fundamental rights now, but you should know that yes, secular state, India's secular state can be evident from these provisions. Universal adult franchise, it means above 18 years of age. It means whoever is considered as adult. It may be possible. Universal adult franchise does not mean necessarily 18 years. First you should keep this in mind. If law says we are going to consider adult about 21 years of age and they will be given right to vote, then that would be also considered a universal adult franchise. But in case of India, voting rights of citizens are given to 18 years and above. Okay, so universal adult franchise. Single citizenship, it means dual polity is not there. It means you don't need a separate citizenship for the state. One citizenship as an Indian citizenship is enough to reside, to move, to work in India. But in case of US, they have citizenship of different state as well as citizenship at federal level. We are going to talk about this in detail when we talk about Article 9 of Indian Constitution. Then we are also going to talk about this in Citizenship Act 1955. Emergency provisions, why they were added. The word emergency itself represents that there may be some threat to the security and integrity of India, and in this case some extra layers of security are needed, and that is why our Constitution mentions Article 352, 356, 360, 365, right? So national emergency, president rule, and financial emergency, right? So emergency provisions are there in our Constitution as a feature. Which emergency has never been used in India? A question for you. Now, three-tier government, what does it mean? We have government at the level of center, at the level of state, at the level of local government. It means Panchayati Raj as well as municipal bodies. But why we need three-tier government? Was it an invention of our Constituent Assembly? No. Three-tier government was actually incorporated during the British time as well. Lord Ripon was considered as father of local government in India, right? So why three-tier government? Because certain basic services which are needed for the people at the local level, they will be best met when power is given to a government layer at the ground. That's why municipality, panchayats were created. 73rd Constitutional Amendment Act talking about giving constitutional status to Panchayati Raj, 74th Constitutional Amendment Act giving this constitutional status to municipalities, municipal corporations. Independent bodies are also a feature of Indian Constitution. For example, Election Commission. Can you actually think of any successful democracy where Election Commission is not given independence? No. So our Constitution ensures free and fair election through independence of Election Commission. When we are going to talk about Election Commission, there is an interesting debate how Election Commission evolved, expanded its power without explicitly these power being mentioned in our Constitution. How during the T.N. Sessions rule, when T.N. Session, ex-IS officer, when he was a commissioner of Election Commission, how he expanded these powers on this interpretation. Since Constitution mentions free and fair election, it means whatever power Election Commission is going to use on the basis of free and fair election, then that power will be considered as legitimate, and even judiciary backed this interpretation with regard to powers of Election Commission. Now, CAG, Comptroller and Auditor General, very much necessary for financial probity in India, right? Then we have UPSC, SPSC. We are going to talk about them in constitutional bodies. So today you are actually having a walkthrough towards our in our Constitution through this chapter, Salient Features. Cooperative societies. A stress is given on cooperative society. 97th Constitutional Amendment Act 2011 gave constitutional status and protection to cooperative societies. Why so much importance to cooperative society? My friends, the word cooperative, it means some people, some groups collate their resources together in order to provide solution to the problem which they were facing on ground. It is a step to tell that every solution may not be state-driven. Many solutions can be society-driven. That is why this fundamental right, this particular right should be given as fundamental right. It made the right to form cooperative societies as fundamental right under Article 19. ध्यान रखिएगा इसको. It included new directive principle state policy promotion of cooperative societies, 43B. It added 9th B in the Constitution, which is entitled the cooperative societies. This is the importance of cooperative society, feature of Indian Constitution. Now, what are the criticisms? First of all, not representative body, not a sovereign body, dominated by the Congress, dominated by the Hindus, borrowed constitution, carbon copy of 35 Act, 35 Constitution, 35, because why this as a criticism? I told you when I was talking about historical background of Indian Constitution, that Government of India Act 1935 actually had so many provisions that they were readily adopted by our Constituent Assembly also, because it fine-tuned the administrative structure during the British time. Then our constitutional framers thought, why not adopt this system which is already serving some purpose? Un-Indian or anti-Indian, it is said that, saying that many provisions are incorporated from outside. Un-Gandhian constitution, because Gandhian ideas of Panchayati Raj as a real government level self-sustained unit will be created at the panchayat level. So those were considered as utopian ideas by majority of the members of Constituent Assembly, and it was taken, yes, we need ideals and gradually we will move in that direction. But elephantine size, among the lengthiest constitution of the world, paradise of lawyers, means huge scope of interpretation is there. We are going to talk about Preamble of Indian Constitution. As mentioned in earlier session also, objective resolution was the source of Preamble, right? Preamble consists of philosophy of our Constitution. By reading Preamble, we can unlock the brain of framers of Indian Constitution. Whenever there is ambiguity in any phrase of Indian Constitution, then you can look what Preamble says, what philosophy, what pillar is mentioned there. Now, let's start with reading our Preamble together. We, the people of India. This phrase stands for the fact that this Constitution is actually a document which is given by people of India to themselves. Because Constituent Assembly members were representative of people of India, right? This very phrase was taken from US Constitution. and US Constitution took this inspiration from the views of famous political thinker Rousseau, who also his ideas inspired French Revolution. A beautiful link here. Now, having solemnly resolved to constitute India, it means people of India are constituting India into sovereign. Now we are talking about nature of state, which we are calling India. It is sovereign. It is socialist. We are going to understand each keyword, right? Sovereign, socialist, secular, democratic, republic. Now these are features of Indian state, right? Now to secure to all its citizens, it means now we are talking about objective of India, right? Objective is justice, social, economic, political. It means 3 type of justice we need to ensure. UPSC has asked question on these objectives. Liberty. Liberty of what? Liberty of thought. You can think without restriction, although there are some reasonable restrictions in place if your liberty of expression is actually threat to India's integrity, security. That we are going to talk about later. But the point is liberty of thought, expression, belief, faith, worship. My friends, you should think why these words were added in first place in Preamble. Why we need justice as a core philosophy of Indian Constitution. The simple reason is, if system is representing injustice, would you like to follow the laws which are made by government? No. There will be rebellion. There will be instability. The only way to ensure peace, stability is where we have a system of justice which is accepted majorly by everyone, right? Liberty. Why you need liberty? You have brain. You have this capability to think, act, to contribute in society. Now tell me, if liberty is not mentioned here, now government can impose restrictions over you. And if government imposes restriction over what you read, what you speak, what you do you think you would be able to realize the potential which nature has given to you? No. And there's a famous saying, no state, no nation can become great by dwarfing its own individuals. अगर आप अपने ही लोगों को छोटा बना दोगे, ड्वार्फ कर दोगे, restriction लगा दोगे, then you cannot become great, right? That is why liberty is important. Then equality. Equality of status, of opportunity, and to promote among them all. Now, among them all, then it is connected to fraternity, but equality of status and of opportunity. Equality of outcome is not mentioned, right? Status, everyone will be treated equally. It means there will be no special privilege for someone just because they belong to a particular religion, particular economic strata, or any such condition, right? You will be having equality of opportunity so that you can use best of your potential, right? Fraternity. Fraternity is very much needed as assuring the dignity of the individual and unity and integrity of the nation. If we don't have feeling of brotherhood as fraternity stands for, do you think a nation can actually prosper? A nation can actually grow? No. We need to have a sense of brotherhood. My friends, these ideas actually make dent on the way a system is going to work, right? Means these values decide the future of a nation. That is why some nations who have strong values towards responsibility they have, towards duty, we have better outcomes in these areas. So these are not mere words. They have impact. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact and give to ourselves. It means people of India are giving this constitution to themselves, right? So why this particular statement is used? So that it established the fact that people of India gave this constitution to themselves. It means now this constitution is legitimate. Now the institutions established as per the provisions mentioned in this constitution are legitimate. Laws as per this constitution are legitimate, and you have to follow them. And when you follow, then only best outcomes can be achieved for India. Now, let's understand what are the different components of Preamble. First, what is Preamble? Ingredients of Preamble: history, keywords, status, amendment, and some fun fact. Now, so as you open a book, so first what you find a preface, right? Now, Preamble is like a preface which is talking about what is actually there in this book. So it's an introductory statement, explains philosophy and objectives of this particular constitution. You can remember this famous statement by N. Palkiwala. UPSC has asked question on these statements. Preamble is identity card of the constitution. Identity card. Basic details are mentioned. Rest are elaborated in form of different parts in Indian constitution, different articles. Now, Preamble to Indian Constitution, inspired by the Preamble of the Constitution of USA, as I mentioned with you. Now, ingredients of the Preamble. This categorization can be done. Sources of the Constitution. Who is the source of power of the Constitution? People of India. Because we, the people of India, give ourselves, right? Objective are justice, liberty, equality, fraternity. Please remember. 4 objectives: justice, liberty, equality, and fraternity. Sovereign, socialist, secular, democratic, republic are not objectives. These are nature of Indian state, the status of Indian state, right? And date of its adoption was 26 November 1949. Now, when we look into the history of Preamble, we find objective resolution which was proposed by Mr. Jawaharlal Nehru on 9th December 1946, which was adopted on 22nd December 1946. So, although Preamble is not enforceable, when I say enforceable, it means you cannot knock the door of court saying that, oh, this particular provision, this particular word is mentioned in Preamble and it is not being implemented. We plead to the court that please implement it. Court will say, beta, from Article 1 to other articles, these are provisions of Indian Constitution, right? So there are 2 kinds of provisions. One are enforceable by law and other are which are not enforceable as of now. You cannot knock the doors. Then you would think, if it is not enforceable, then why it is added? It is added so that it can be used to understand what constitutional framers meant by certain article, by certain phrase, right? So it is used in interpretation whenever there is ambiguity. Ambiguity means when there are more than 2 meanings deriving out of a particular sentence, then you can look into Preamble. What are the keywords? We, the people of India. It indicates ultimate sovereignty is with the people. Now, why this arrangement was made? So that no government in future can undermine people, because ultimately who is the source? People are the source. Sovereign, this term represent that you are beyond any external or internal influence. It means Indian state is completely free to take decisions with respect to internal and external matters. So sovereign word represents that you are independent authority, you are not a dominion. Okay, you are not a dominion. Internal external matter, your decisions would be considered final. Now the second word, socialist. Why we added socialist? In our history we know that a private company came into India and then became territorial power, made us slaves, colonial power. Now the point is, we have seen that private company worked for its own gain, sidelined what was necessary for the common masses. Exploitation happened. So this can only be resolved when nature of Indian state is socialist. It means government should think of people on ground. They should ensure that power, resources should not concentrate in the hands of few people. It means achievement of socialist end through democratic means, because this word socialist has different connotation. For example, Marxian and Gandhi both talked about socialism, but they had different views. We are going to talk about it. So it means this word socialist, I hope it is quite clear why it was added, right? Now the point is, this was not part of original preamble. It was added later. 42nd Constitutional Amendment Act. My friends, our preamble has been amended only once, during the time of Indira Gandhi ji, and then at that point of time the socialist word was added. Now why this socialist word was not in original preamble? Because our constitutional framers thought already in part 4, directive principles of state policy, we have mentioned the provisions that these should be directives when government is going to plan policies in future. Government has to take care of socio-economic development of the people. Government has to take efforts so that resources are not accumulated in few hands. Government has to make efforts to reduce exploitation. So it means these provisions were very well present, then that's why they did not added it specifically. But Indira Gandhi ji's time it was added. This is democratic socialism. It means we believe in democratic processes. We elect our representatives, and on the basis of these representatives we have a government. So through this democratic process we want to achieve socialist outcomes. Now UPSC 2 years back has asked question on the difference between Marxism and Gandhism. Marxian idea of socialism and Gandhian idea of socialism. Let's understand this difference, although you should know that when socialist word is used in Indian Constitution, when socialist based principles are used in our DPSP, they are tilted toward Gandhian socialism, not Marxian socialism. Now what is the difference? Please have your attention here. Marx, who born and who grew in Prussian state where we have Germany now. So he was living at a time when there was rapid industrialization, and in this industrialization he saw that government is not making any law for protection of the interest of workers. Workers are bound to work for 16 hours, 17 hours in difficult circumstances, and they are given meager wages. And what is the result? That these workers are exploited continuously. And who is accumulating the profit? These factory owners, these capitalist class is actually accumulating these profits. So at that point of time, he said we need scientific socialism, and he said it is a prediction that it is going to come. Marx said, I'm not saying that this will be a fabricated attempt. No, it is bound to come. It is natural. He said, since there is accumulation of wealth towards these factory owners, capitalists, there will be a lot of difference between haves and have-nots. Haves, those who have capital, surplus; have-nots, those who are just fighting day and night for meager survival. So there will be a stage when this difference between haves and have-nots will increase to such a level that these have-nots will attack these haves. There will be a violent revolution. Now Marx said it is scientific socialism. He said, what I'm saying is scientific. When we use the word scientific, science as a discipline is based on observation and telling the principles how things are working. So he said, I have observed this. In history, always, there are two kinds of classes. One are exploiter, other are exploited. In ancient time, there were masters and slaves. Masters, exploiter, slaves were exploited. Then we had lord and serfs. Lord, having big land holding, serfs who used to work as bonded labor. And now in modern time, we have capitalists, big and factory owners, and workers are like exploited class. So he said at every point of time, society was divided into two classes. And cause of this exploitation was that exploiter was having a lot of resources in hand. An exploiter could actually gain these resources not due to some natural fact, but because the system was in favor of this particular class, the exploiter class. And how it happened, I'm going to explain. But he said violent revolution is the only solution. Because person who has nothing to lose is the most dangerous person. He can do anything. Right? And same was true with respect to these workers. They were not having any property. So that is why Marx said, workers of the world unite together. You have nothing to lose but your chains. Now, some of you might be thinking why he was telling this, because he wanted to emancipate the worker class. So this is one fragment of Marxian socialism. But when it comes to Gandhian socialism is based on this idea of moral individualism. Gandhiji brought morality here. Gandhiji said, real cause of exploitation is that we have wrong conception of dignity. In our society, we give more dignity to intellectual labor than physical labor. And this is the root cause of exploitation. And that is why Gandhiji brought the concept of dignity of labor. That the work of barber, work of sweeper is equally important, is equally dignified as work of a lawyer. Right? So he said, if we bring this shift, this moral shift in society, then this exploitation tend to reduce. Apart from this, Marxian socialism stands for the point of social ownership. Social ownership. What does it mean? He said the cause of exploitation is ownership, because only few have ownership. They have accumulated wealth. Now I'm giving you an example. Consider you have a factory and you have to make this remote. Okay? And to make this remote, you have spent 20 rupees, say, in raw material, transport, and etc. 30 rupees you have divided among labors, right? So it means total cost is 50 rupees. But you have sold this particular remote for 100 rupees. Now you have earned a profit of 50 rupees, right? So now this profit is accumulated in your hand because you are the factory owner. Marx said, this remote is a social production. So many people, laborers, they give their time, they give their efforts to make this remote. Then why not profit is actually shared with them? It is a system which we have created. He said, this is a natural fact that this remote is being created by contribution of different laborers. This is a natural fact. But this is a fabricated arrangement. This is a fabricated arrangement. This is a social construction. We have created this, that profit will be with only that person who has invested in this factory. So that is why he favored social ownership. It means when it comes to these profit, even these labor should have ownership of this profit. But when it comes to Gandhiji, Gandhiji was never in favor of this idea. Gandhi said, if 50 rupees are profit, then you should also respect that entrepreneur, because he invested the intellect, he arranged this factory. And that is why he said, yes, it may be a cause of exploitation, but we can reach to a better concept, which is trusteeship. Gandhiji said, out of this 50 rupees, it may be possible that this particular industrialist will spend 10 rupees on his own well-being, another 10 rupees or 20 rupees for further investment, and remaining 30 rupees, this person which is having this 30 rupees, this can be spent for social welfare. Because ultimately Gandhiji was also saying that every production is a social production. So if you have accumulated some wealth, don't think it is your wealth just because it has come into your bank account. It has come into your bank account because system is designed in such a way that you are considered as owner of this 50 rupees. But who made you owner? The system made you owner. Who made the system? People made the system. Why people made the system? Because some people could actually gain power by making this system. So Gandhiji was in favor of trusteeship model, right? So This is the basic difference between Marxian socialism and Gandhian socialism. I hope it is quite clear to you. Please remember the keywords: scientific socialism, moral individualism, social ownership, trusteeship. Okay. Now, attempt this question, because sovereign socialist, now we need to understand the word democratic. Okay. So UPSC might ask this kind of question: democratic character of Indian polity is not manifested in. So UPSC will give you certain options and ask which of the following is not a manifestation of democratic character of Indian polity: universal adult franchise, periodic elections, rule of law, independence of judiciary, absence of discrimination. And options, obviously these are the options, and you have to select from 1 and 2, only 5, only 3, none of these. Aapki shraddha hai, whatever option you want to make. This is the question. Now some of you might use your brain and say democratic character, not manifestation. So universal adult franchise is manifestation of democratic character, right, in Indian polity, that you have voting power. Periodic election, yes, elections are connected to democratic character. Periodic election, these are necessary for democratic character. So not में ये तो नहीं आना चाहिए. It should not become in note. Rule of law, rule of law. It means no one is above law. State cannot engage into arbitrary action. Is it connected? Now, independence of judiciary. What is the connection of democratic character with independence judiciary? Some may actually question that. Absence of discrimination. How it is connected to democratic character? So it means these two options people connect with democratic character, obviously, but when it comes to these other three options, people don't usually connect that much obviously with this democratic character word. But the truth is, all 5 are manifestations of democratic character, because you cannot think of democracy without rule of law. Law should be supreme. Only then you can think of democratic character. People would be able to exercise their choice only when there is low rule of law. And this is possible when there is independence of judiciary. Whenever a particular party, leader, they commit certain mistakes or certain actions which may threaten the democratic character of Indian polity, you can go to court and court can pronounce a judgment. Don't you think it is necessary? Right? In earlier times, there used to be a lot of cases of booth capturing. Means some local politicians have collided with some ground people, and now they have actually taken the ballot box and ran away so that they can influence the elections. So now judiciary actually took several judgments to strengthen the position of election commission, and that's how democratic character of Indian polity could be, you can say, saved. Similarly, absence of discrimination. My friends, democratic character word is not just form of government. Democracy is an idea which talks about equality as well, liberty as well. You have liberty, then only you can exercise your right to vote. You have equality, then only you will think, yes, this government is equally mine as equally as it is of this rich person. So democracy is a substantive idea. It is quite wider, right? So absence of discrimination is necessary. Then only people will participate in the election process. Otherwise, people will think this is wastage. Now, coming to the word secular. The word secular which India is having is different from the connotation of word secular which is prevalent in France or some other European nations. When this word secular became popular in West, it was about clear separation between state and church, because they have seen dark age of Europe where church was having control in executive power, in legislative power, in judiciary. Church used to sponsor mercenary fighters also. So they have seen the chaos which religious people made at that point of time. So that's why they wanted that religion should be a matter of private sphere, and when it comes to public sphere, only state laws should run the show. This is clear separation. But when secular word is used in Indian Preamble, it is different. It is based on Sarvadharma Sambhav. It means religions in India get equal respect protection and support. Support is also there, protection is also there, respect is also there, right? So it incorporated in preamble by 42nd Constitutional Amendment Act when the word socialist was added. It was not originally part of Indian Constitution. Why? Because our framers thought we already given so many articles which represent the secular character. Why mention this word separately here? Democratic Constitution gets authority from will of the people. This is the meaning. Will of the people. People are deciding who is going to rule, right? And from this, I ask that question. The democratic character, this represents the manifestation of these points, right? Indian Constitution provides for representative parliamentary democracy. What does it mean? It means we elect our representatives, and then these representatives, on the basis of majority, then government is formed, and this government is actually responsible towards legislature. It means they have this status of having government only till that point they have majority in legislature. Right? Now, the word republic, it represents that head of the state is elected. Means it is not hereditary. For example, Britain cannot be considered as republic. Britain is a monarchy, right? But India is a republic because a head of the state is president and president is elected. Okay? I'm making some statement. You have to tell me the statement is true or false. The position of Prime Minister in India, or you can reframe it like this also, that Prime Minister is elected in India for a term of 5 years, although this term can reduce before that. I mean, this term can actually finish, or this position may be absolved before that. Now, do you think that statement is true? What do you think? The statement is true or false? My friends, एक तो होता है गलत, एक होता है सरासर. ये सरासर गलत है. Because position of Prime Minister is not connected to election. You vote for member of parliament, and from these member of parliament, one person is appointed as Prime Minister. So there is no election for the position of Prime Minister in India, but there is concept of election for the position of President in India. That is indirect election. We are going to talk about it when we talk about President, but this difference should be clear in your mind, because UPSC play on these, you can say, keywords. And Prime Minister does not have any tenure. Okay? Because Prime Minister is there till the time this Prime Minister is having confidence of the House. Majority votes, majority of the Lok Sabha is in favor, of this Prime Minister or this government. Now, the word justice. I told you why justice was added, because only then we can actually maintain order in society, right? Promise through fundamental rights, DPSP, that state will ensure justice will be prevailing. Means how we can prevail justice? We have to strike on any ideology, any practice which is connected to injustice. So various protections are given in fundamental rights. For example, Article 15 saying that no one shall be discriminated on the basis of religion, race, caste, sex, place of birth. So don't you think it is an attempt to provide justice? Now, what kind of justice we have? We have three kinds of justice maintained or mentioned in our preamble. Social justice. What is social justice? It means you will not be discriminated on the basis of your social condition. Means social conditions may be caste, creed, gender, religion. You will not be discriminated on this basis. Economic justice. There will be no discrimination on the basis of economic status which you are having, wealth, income. Along with this, the state will actually make sure that enough earning opportunities are given to you. This will be economic justice. Political justice. There will be free and fair, right? There will be free and fair conduct of this process of election, and along with this, you will be given opportunity to vote and also present your candidature based on the criteria which is mentioned. So you have this right to participate in political process. This is political justice. And why this was added? Because, my friends, these laws shape your life, impact your life, right? And since they are impacting your life, you should have stake. You can engage, right? Most of the people think that social justice and economic justice is important, and political justice can be considered as third level, right? But a society in which people are not aware of the importance of political justice, in that society, authoritarianism, exploitation may be seen easily. Because people are not aware about their rights. People are not aware about their duties. People are not aware about the importance of engaging into political discourse. What is happening, what law government is making, why this is in debate. If you're not aware of this and you're not having any interest in this, then my friends, this society may crumble soon. Because if you are not aware of what is right and what is wrong, then some people, crooked people, will rule you, will rule the society, and they will crumble the society, weaken our foundation for their own benefit. And that is why concept of political justice is equally important. When you are aware, you are participating in political process, then there are less chances that people can actually mend rules for their own favor or crumble the foundation of Indian polity. Equality, no special preference, no special privilege. And we have Article 14 to 18 talking about equality, fundamental rights related to equality. Why equality was necessary? This is also a modern concept. It means in ancient time, this idea of equality was not that much present. If king has said something to you that you will be given this punishment, another person who has committed same crime, but that person was given less punishment. So at that point of time, if you're questioning the king, you will be terminated, my friend. But in present context, you have more rights. The reason, the concept of equality is quite prevalent here, right? Everyone is equal before law. Everyone is equal before law. Liberty. As I told you, importance of liberty. Only then people can realize their potential. Only then people can contribute in society. Only then India can actually prosper, progress. So liberty does not mean freedom to do anything. You have some reasonable restrictions there. Your liberty should not impact the liberty of other person, right? That is why some limits are also set by law. For example, in fundamental rights, when I'm going to talk about Article 19, subclause 1, subclause A, B, C, D, so then in subclause 2, I'm going to talk about reasonable restrictions also, right? Fraternity means feeling of brotherhood. It is also equally important. This way we can actually have support of one another, and support of one another is necessary aspect of any society. And this can be done when we promote dignity. That's how brotherhood is going to happen, right? Unity of the nation. So these are the three mottos of French Revolution: liberty, equality, fraternity, given by famous political thinker Rousseau. Now, attempt this question. The language and ideals of the Preamble of Constitution India is influence borrowed from which of the following constitutions? Answer is ABC. Fourth. Now, status of Preamble. Is Preamble part of Indian Constitution or is just a preface, not a part of Indian Constitution? So there has been a debate on this, and now this debate is settled. In Berubari case, Supreme Court said that Preamble is not part of Indian Constitution. They said actually it can be used to unlock the mind of constitutional framers. It can be used to interpret Constitution, but it cannot be considered as part of Indian Constitution. Open the mind, right? Now the first point which should come in your mind is why we are having this debate on whether Preamble is part or not. There's a reason to that. If Preamble is declared as part of Indian Constitution, then Article 368 can be used in Indian Parliament to amend Preamble, because Article 368 gives power to Parliament to amend any part of Indian Constitution. So if Preamble is considered as part, then Article 368 will be applicable and this can be amended. If it is not considered as part, it means power of Parliament to amend Constitution, any part of Indian Constitution, will not be applicable over Preamble, right? Now, in case of Nand Bharti case, the Berubari judgment was actually reversed. Now, in case of Nand Bharti case, Supreme Court said, yes, Preamble is part of Indian Constitution. Now Parliament was like, we are elated, now we can amend the constitution the way we want. Kesavananda Bharati के Supreme Court says, अभी स्टोरी बाकी है मेरे यार, पूरी बात तो सुनो. पूरी बात ये है कि you can actually amend preamble, enjoy. But the point is, you cannot flout the basic structure of Indian Constitution. You cannot change the basic structure of Indian Constitution. Basic structure of Indian Constitution, this phrase is not mentioned in Indian Constitution. Then Parliament was like, government was like, what is this basic structure of Indian Constitution? Supreme Court said that we are going to decide time to time, because we are the ultimate interpreter of Indian Constitution. So as of now, preamble is considered as part of Indian Constitution. Parliament has power to amend Constitution. Yes, Parliament has power to amend Constitution, but Parliament has to consider that it cannot change the basic structure of Indian Constitution, right? Now, in the next case on the same topic, LIC 1995, in this case again, Supreme Court accepted, yes, preamble is part of Indian Constitution. So at this point of time, preamble is part of Indian Constitution, can be amended but cannot be flouted, the basic structure of Indian Constitution. Now, amendment to the preamble. There is only one time amendment happened, 42nd Constitutional Amendment 1976, as I told you. At that point of time, it was quite clear that you cannot change the basic structure. So taking inspiration from the provisions which are already mentioned in the Constitution, 3 words were added: socialist, secular and integrity. Socialist and secular were added between sovereign and democratic. It means telling nature of Indian state. Unity of the nation was earlier phrase, now unity and integrity of the nation was actually made here. Now there's a fun fact. On 26 January 1950, the final enactment happened and Constitution was anointed on 26 November 1949, right? So on this date, certain provisions of Constitution became applicable, right? For example, these articles related to citizenship, election and provisional parliament, and full-fledged Constitution was enacted on 26 January 1950. So I hope this short discussion on preamble, on important aspects of preamble, it's quite clear to you. For this PDF, you can find this PDF in this Telegram group, Shashank Tyagi for you. I'm available on Insta and Twitter. If I could be of any help in your preparation, shoot me a message. I'll be there. See you.